Item 1.
Okay. Written argument दिसला है तो कुछ petition में तो written argument दिसला
खाली पन्ना देखिए. No, after your completion, I'll submit certain
So,
judgment.
madam, you have nothing to argue in this matter.
No, I have to submit the judgments. I have made a judgment. Certain judgments are there
Okay.
in support of my argument. That day I could not able to supply because of the non-availability of the
Okay.
photo state.
Okay.
I have already marked, so I'll apprise after completion of his part.
After completion of his argument.
Or as your lordship pleases. If you say that I will, lordship will say, then I will
So,
start.
Bora, first let her complete her part.
Your lordship, on that day, there was an issue with regard to the child witness who has been subsequently declared as a juvenile. And since there is no joint trial, so his 164 may not be taken into account. However, I have brought certain judgment with regard to the child witness. And to that effect, your lordship, section 311 speaks with regard to the calling of any witness. So at the best, the person who is declared as a juvenile, he can be called as a witness.
No, whether you have made such a prayer before the trial court?
No.
No.
No such prayer is there because trial is not yet started. During the time of charge framing, charge hearing, the case has been discharged.
Okay.
So that stage has not yet reached.
Okay.
So it has to reach that stage. So 311 speaks with regard to the power to summon the material witness or examine person present. Any court may at any stage of any inquiry, trial or other proceeding under the court.
No, at the stage of framing of search, where is the question of invoking this power? 311.
Sir, at the stage of trial, this power can be invoked at the stage of trial, Your Lordship.
No, maybe. The accused was discharged at the time of framing of search.
Yes, Your Lordship.
So where is the scope of invoking this provision at that time?
So my concern is that if the matter will, either way, if it is remanded, in that event, because I have to argue on the merit because there is no eyewitness. And the person who is an eyewitness, he has been declared as a...
Madam, you say, to remand the matter, we have to interfere with the impugn order.
Yes, Your Lord.
And unless you assign sufficient ground for interfering with the same, we cannot.
So, because this power is also vested upon the trial court to call the witness.
When this power has to be invoked? At what stage?
At the
Is it at the time of consideration of search?
Yes.
Is it?
At the stage of trial, at any stage it is written.
No. At the stage of framing of search, is there any scope for invoking section 311?
My concern is that because discharge due to want of certain evidence. So my concern is that the trial court has not taken into account that even if that person has been declared, that accused has been declared as juvenile, his statement 164 cannot be taken here because the joint trial cannot be done. However, the court could have considered that he can be made a witness at any stage by invoking the power of 311. So before that, it has been discharged. So the process has not yet reached, and the trial court has come to the conclusion that there is a no prima facie case. My concern is that there is a prima facie case, even if it is a juvenile has been sent to the juvenile board. However, his evidence can be taken by invoking the section 311.
No, that is only at the stage of trial, not
Yes,
at
Your
the
Lordship.
stage of framing
So
of
before
charge.
reaching to that, my case has been discharged.
No, merely because that one witness has to be examined during trial, the court cannot frame charge.
So other circumstances and the evidence of the other material witnesses are there.
That's all right. You show what are the material the trial court has not considered at the time of framing of charge.
So one thing is this one that the juvenile has.
No, I don't
for
think
a
this
witness.
this will help you.
The child witness he is a competent witness.
No, there is no doubt about it. There is no doubt about
And
it.
even the conviction can be done with the solitary witness. To that effect, I have a judgment, Your Lordship. I have taken out the solitary witness. At the, First one is one article with regard to the competence of the child witness and legal framework under section 124 of the Bharatiya Sakshya Adhiniyam. So I am not going in it because it is an article and it is a narrative with regard to the child witness. I am coming to the judgment 2. We have already written in the upside 2. That is with regard to the solitary witness. Page para 50.
Yes.
Para 50. The learned counsel for the appellant has contended so as since a large number of witnesses, including a punch witness and some of the alleged eyewitness, have turned hostile, the appellant is entitled to the benefit of the doubt. We are unable to accept the said submission. It is a settled principle of criminal jurisprudence that it is the quality and not the quantity of evidence which is determinative. Even the testimony of the solitary witness, if found to be wholly reliable and of a sterling quality, is sufficient to base the conviction. In this context, we would note that the judgment of this court in Namdev versus State of Maharashtra, with the benefit wherein it has been elaborately explained the evidentiary value of the credible solitary witness and has held that the conviction can be founded upon upon such evidence. So, and thereafter this some part of the other judgment has been elaborated here.
No, madam, you say.
Solitary judgment he can call for as a witness.
No, your case did not reach that stage.
We are not
How this decision will help you?
How to reach at that stage. Before that, without considering all this law point, the matter has been disposed.
You argue on the point of what are the points to be considered at the time of framing of charge. What is the standard of evaluating the materials at that stage?
That is the prima facie case. What is
you were referring these judgments which are applicable at the end of the trial, which are to be considered at the end of the trial.
These are the points which will support us at the time of framing of the charges, Your Lords. Then third is with regard to the evaluating testimony of the child witness, which has been discarded at the time of framing of charges, Your Lordship. This was discarded. Even if it is splitted, his evidence can be taken into account, at least for contradiction or corroboration. And thereafter, at the time of trial, he could have been summoned for the witness. This is a quite big judgment. I have relevant portion has been flag marked here.
Okay.
Then thereafter, It's a too long. Shall I go through?
Pardon?
It is
Not,
too
not
long.
necessary. You come to the next judgment you have relied upon.
Yes. Another one is with regard to the 164, Your Lordship, and that is 27,
Yes.
para 27. The jurisprudence concerning a statement under section 164 CRPC is fairly clear. Such a statement is not considered as a substantive piece of evidence, as a substantial oral evidence is one which is declared before the court and is subject to cross-examination. However, section 157 of the Indian Evidence Act makes it clear that the statement under section 164 CRPC could be used for both corroboration and contradiction. It could be used to corroborate the testimony of other witness. In R. Saji and State of Kerala, this court discussed the twofold objective of the statement under section 164 CRPC, as so far the statement of witness recorded under section 164 concerned the object of twofold. In this first place, to deter the witness from changing his stand by denying the content of his previously recorded statement, and secondly, to tide over immunity from the prosecution by the witness under section 164. The proposition to the effect that if a statement of witness recorded under section 164, his evidence in court should be discarded is not at all warranted. Then I am coming to paragraph 28. Considering the conceptual requirement of recording a statement before the judicial magistrate during the course of investigation and utility thereof, as prescribed in section 157 of the Evidence Act, it could be observed that the statement under section 164, although not substantive piece of evidence, not only meet the test of relevancy, but could also be used for the purpose of contradiction and corroboration. At least his statement could have been taken into account while before discharging the accused. A statement recorded under section 164 CRPC served a special purpose in a criminal investigation, as a greater amount of credibility is attached to it for being recorded by the judicial magistrate. Thereafter, the last but 4 line, ultimately what count is whether the court believes a statement to be true, and ultimately test reliability happens during the trial upon calculated balancing of the conflicting version in light of other evidence on record. Now I'm coming to Your Lordship, 5th judgment.
Yes.
Para 7 and 8. It is well settled law. At the stage of framing of charge, the court has power to sift and weigh the evidence for the limited purpose of finding out whether or not the prima facie case against accused has been made out. When the material placed before the court discloses a great suspicion against the accused which has not been properly explained, the court will be justified in framing charge. No roving inquiry into the pros and cons of the matter and evidence is not to be weighed as if the trial was being conducted. If on the basis of material on record, a court could come to the conclusion that commission of the offense is probably consequence, a case of framing of charge exists. 8. To put differently, if the court were to think that the accused might have committed the offense, it can frame a charge, though for the conviction of conclusion is required to be that accused has committed the offense. At the stage of framing of charge, probative value of the material on record cannot be gone into. The material brought on record by the prosecution has to be accepted as a true at this stage. As the truth, veracity, and effect of the evidence which the prosecutor proposed to adduce are not to be meticulously judged, nor any weight is to be attached to the probable defense of the accused. It is not obligatory for the judge at the stage of trial to consider in any detail and weigh in the sensitive balance whether the fact, if proved, would be incompatible with the innocence of the accused or not. Paragraph number 9. The standard of test and the judgment which is to be finally applied before recording and finding regarding the guilt of otherwise of the accused is not exactly to be applied at the stage of deciding the matter under section 227 or under section 228 of the code. But at the initial stage, if there is a strong suspicion which leads the court to think that there is a ground for presuming that a accused has committed an offense, then it is not open to the court to say that there is a no sufficient ground for proceeding against the accused. While deciding the question of framing of charge in a criminal case, the court is not to apply exactly the standard and test which it finally applies for determining the guilt or otherwise. Then paragraph number 10, what is required to be seen is whether there is a strong suspicion which may lead to the court to think that there is a ground for presuming that the accused has committed an offense. The above proposition is supported with the law laid down by the Honorable Apex Court and the Honorable High Court, reported as Union of India versus Prafulla Kumar, AIR so and Thapa versus so and State of Bihar versus so. So while deciding this case, the Honorable Apex Court has also relied upon this court, which has decided by the Apex Court, and this judgment covers our case, Your Lordship. This judgment covers our case.
Okay.
Now I'm coming to 6. That is para 9, page 25. Para 19, Your Lordship, not 9, page 20. Same here also, the reference of the Ramesh Singh State of Bihar is also given in paragraph number 19. A different discipline governs the case arising at the stage of discharge, framing of charge, or prima facie satisfaction. The court has consistently held that at this stage, the court is not concerned with the proof of guilt or the sufficiency of evidence for conviction. The State of Bihar versus Ramesh Singh and the later Union of India and Prafulla Kumar Samal, the court clarified that the test is whether the material on record taken at face value discloses the essential ingredient of the alleged offense and give a rise to the strong or grave suspicion against the accused. The court is expressly cautioned against the conducting a roving inquiry or weighing the evidence as if at a trial, when this generally applicable principle are applied to an appeal under section 14A of the SC and ST Act arising from threshold order. The High Court's role, though appellate in nature, stand circumscribed by the limit governing discharge. The High Court may examine whether the allegation disclose the basic statutory ingredient of the offense under the Act, including whether the alleged act was committed on account of the victim's caste. This is with related to their case. But however, this case has covered our case, this judgment. So this is the last judgment wherein, and this followed by my child competence. His witness is he is a competent witness. So during the framing of charges, I am relying these two important judgments.
Mr. Borda.
May I please the motion? Before going into the legal issues, madam, I just like to give the basic facts for your lordship. These are very important, some issues are involved. Well, what happened in this case in 2000, 27/9/2000, and FIR was lodged by one Manik Dhara before the Gauhati police station. So the FIR's brother has been killed by some unknown assailant in the nearby to his residence in the meantime. That was his brother was missing, so that was the initial first FIR by the brother in the Gauhati PS case file. So that case after that case has been transferred to CID to investigate by the state government. That case was transferred and the CID thereafter taken the investigation, interrogated all the witnesses relevant. In the meantime, when that case was pending during the investigation, the brother, the informant, filed a writ petition before the Honorable High Court for handing over the matter to the CBI. So, but in the meantime, when the matter was delayed and the hearing was not taken place, one did the High Court, which without calling for the status report of the CID case, madam, which is pending, directed for the investigation. What was investigation? No further, no fresh. Only investigation was directed. So accordingly, then thereafter the CBI, they have registered their own case, own number. And they also started the investigation afresh. So the High Court order was absolutely silent whether the investigation will be a fresh one or the further. Only the investigation was directed. In the meantime, the CID has also filed the charge sheet before the Honorable Court, madam, competent court in the Vishwanath Sarkar. In that CID investigation, my lord, I am not an accused. Two other persons shown to be accused, and one is the absconder. Both the respondent, they are not accused in the CID case, my lord. One against one Narayan Gaur and Umakanto Mate, and one Kalemeja, who is shown to be an absconder. The CID finding such. Now, thereafter, the CBI also taken the investigation. They have all their own, started the investigation. Then they have filed the charge sheet also in the Special Court of Magistrate in Gauhati. And thereafter, the case was committed to the Session Judge Gauhati, madam. At that stage, madam, when the charge hearing took place initially, the charge was framed against the accused. We have challenged that charge order for this Honorable High Court. The first. Then, my lord, our contention in the High Court, apart from some other legal issues, my lord, the main issue was that the CBI cannot just brush aside the investigation carried out by the CID, because there is no direction of the fresh investigation by the High Court. So it is mandatory for the CBI to take those material also while filing the charge sheet, because there is no direction of the fresh investigation. So to that effect, we have placed a certain judgment of the Honorable Supreme Court, and the High Court, by order dated, my lord, 11/6/2013, it's also reported, my lord, has accepted our contention, relying on the judgment of the Supreme Court, that when there is no direction of the fresh investigation, CBI is bound to take up the investigation carried out by the other agency while they have taken the investigation. So both the investigation, the trial court was directed also, paragraph 36 onwards, the High Court has directed to take up both the charge sheet together to decide afresh regarding the point of charge. So accordingly, matter was remanded back to the, and High Court also observed the other points, that we have a substance in the weight in the arguments of the learned counsel petitioner, and remanded back to the trial court for a fresh decision, in which as the learned session judge has to take a fundamental decision, paragraph 21, as to which of the two theories, as pronounced by the CID, and altogether different story projected by the CBI, has to be accepted. In view of the judgment of Honorable Supreme Court rendered in the case of Binay Tyagi Supra, it is for the trial court to accept the supplementary report or reject the same, as can be done in respect of the preliminary report, original charge sheet dated so and so. For the following reasons, the in order to take so and so framing of charge against the accused person is hereby set aside, quashed, and the trial court is directed to re-examine the case in light of the legal points and issue raised by the accused person. So, again, it was remanded back to the trial court. And now in the trial court, what happens, my lord? Initially, the other co-accused, one of the common law, my lord, he filed a petition, my lord, that he being a juvenile during the time of alleged incident.
Hmm.
So the trial court at that stage made an inquiry as per the Juvenile Justice Act and came to a finding on 18/12/2013. There is an order by the session judge, and session judge by 18/12/2013 come to a conclusion that the declared Kamalnath as juvenile after considering the report of the medical board and evidence placed by him, and thereby split up the case from the session case number 60 up to 2008. So by order dated 18/12/2013, the trial court, before framing of charge, case has been split up and juvenile, the common law, his case is remanded for the juvenile court for the trial. So this is the basic background. So now comes to the legal proposition in this case, madam. Apparently, madam, in this case, apart from the confession of that particular juvenile, this is a confession, my lord. There is absolutely no material. They cannot show any material. Forget about the prima facie, madam. Not even the whisper against these two persons, madam, against the accused, madam. Respondent. Except that confession, madam. Now, regarding confession also, it's very peculiar, my lord. Initially, there was no confession, madam. When the CBI took up the investigation, even when the CID also took up the investigation, initially there was no confession. The confession was recorded after 6 years, if I'm not wrong. And that too very in a peculiar way, my lord. Where from they came to know that these juvenile is also involved. They came to know that juvenile from a newspaper report, my lord. It is in the search sheet. Their case is that from one newspaper report, they came to know they one juvenile is also involved. But surprisingly, so accordingly, his statement has been recorded after nearly 7 years, madam. 6 years after the alleged incident, and that too on the basis of a newspaper report. But in Lordship will find it has also been reflected in the judgment of our High Court while remanding back the case that is surprisingly that newspaper nowhere in the scenario, madam.
Nowhere
In the scenario, madam. There is no
Okay.
newspaper of that particular name who has published that newspaper from where they get to know that there is one juvenile.
whether that newspaper was seized by the CBI?
No. No existence of that newspaper. Even we have made an RTI, which is also placed to the trial court, that there is an order as per we made an RTI. And the RTI report also says there is the newspaper by the name A Hopta. It's nowhere exists. And neither in the record, who's the publisher, where from they got the newspaper, not even a single copy in the record.
No, that newspaper was not seized.
Not seized. Not seized, even nowhere in the existence as per the RTI report.
Okay.
But they somehow, the CBI of their own, probably they have also started publishing newspaper at that time. We don't know. Maybe. They are the big shot, they can publish the newspaper also, if required. So, but they have not seized it, nowhere. Now, let us see the legal proposition. So legal proposition that regarding in the stage of framing of charge, the court has to look the material collected by the investigation independently without relying the co-accused statement. Co-accused statement only as a corroborative evidence. That too in the end of the trial. The law is very subtle, my lord, that the prosecution cannot start, even at the stage of framing of charge, the co-accused statement. It was a co-accused statement, apparently. So, prosecution cannot start with the co-accused statement, then they will find out the other corroborative evidence. It is other way around. They have to place the material first, their independent material, then they can corroborate with the co-accused confession at the end of the trial. If the confession at all, they are in the record. It is only a corroborative piece of evidence. Here, what is happening, my lord? CBI all the time, they are coming with the co-accused statement as their basic material. Because there is no material otherwise. They are always saying there is a co-accused statement, co-accused statement. But at what stage you can consider the co-accused statement? It's a corroborative piece of evidence. Because the co-accused statement, the confession, is not subjected to the cross-examination. So it cannot be taken as a substantial piece of evidence under Section 3 of the Evidence Act. That's the law. Because it's not subjected to any cross-examination while making the confession statement. So that's why the Supreme Court say even at the framing of charge, you cannot start with the co-accused statement. You have to first place the material of the independent material, then you can rely the co-accused statement. That is the law. I'll place the judgment final one by one. So now the second part is the most important. Now when the co-accused statement can be relied on. So as per the Section 30 of the Evidence Act, the Lordship knows it very well, that if both the accused are facing the joint trial, Evidence Act Section 30. If both the accused are facing the joint trial, then only the co-accused statement can be relied on as a corroborative piece of evidence. Lordship, just for my sake of Lordship, kindly take up the Section 30 of the Evidence Act. So it says regarding the joint trial. Only in that case, only applicable during the. So in this case, trial is yet to start. Trial will start after the framing of charge. So only the joint trial, my lord. So here the trial is yet to begin. Trial will definitely begin after the framing of charge, not prior to that. There's a lots of judgment when the trial starts. So they cannot rely on the basis of that because your co-accused is already declared being trial and he is facing the trial in a different proceeding, not in the joint proceeding. First requirement is that. Apart from his my lord, the one most important factor is that the confession. If we go by that confession, if you accept also for the sake of argument, Lordship will find this cannot be treated as a confession because of the fact that it is absolutely exculpatory statement. He has nowhere made any statement in that particular statement that he was also part of the conspiracy. He is not involved. So if we go by the confession also, it can't be taken as a confession. It is just a statement of the fact, not statement of the guilt. The confession means the statement of guilt, not statement of fact. Both are different. Here, if we take up that statement also, Lordship will find It's just a statement of fact, how it has happened. That he went to an hotel. Then there's a discussion of the accused person. There initially there one more accused person. They were discussing how to execute the plan. He was part of that discussion. He was waiting. Then some money was transaction between the accused, one person, and surprisingly, there are two persons. Apart from me, one more person who died was the MP of Tejpur, that side. He was also present along with me as per the confession, very surprisingly. But he was not made an accused by the, if you go by the Lordship will be the confession, Lordship will find that the MP, I was not MP at that time, the other MP was also present at the time to eliminate the, as per their theory, he had handed over 6 lakhs of rupees to one accused who executed the plan. But the CBI, surprisingly, is exonerated that. Why? There's no reason. If they are relying on the confession, they have exonerated the MP. Now, CBI's case is that from the very beginning, they are relying on the what is the material that he also stood in election along with me. I lost because he secured 3,000 votes, and I lost because of that 3,000 vote. So if I eliminate him, that 3,000 will definitely come to me in the next election. So I'll be a winner in the next election. This is just a presumption, my lord. So on that presumption, they have come with that conclusion that I am the beneficiary, prime beneficiary for his death. So the whole case is, my lord, only the basis of some presumption. And the lordship knows the presumption cannot be based on another presumption. Their whole case is on the basis of the presumption, my lord. And they are also presuming that the vote, it may not, my lord. There's another presumption, my lord. So presumption cannot be based on another presumption. It has to be based on certain facts. Where is that fact? Just because he stood in the election along with me and he secured 3,000 votes and I lost that particular election because of him. So I'll eliminate so that that 3,000 in the next, after 5 years will definitely come to me. It's an absolute presumption, an absolute presumption. Now, if we go by at the stage of framing of charge also, if lordship goes take up both the material collected by the CID and the material collected by the CBI implicating me, both are in two different directions. The accused are different. So there's basically, out of the same investigation, now there are two theories. One theory implicated me on the basis of the confession. The other theory, nowhere. The CID investigation, nowhere I have been implicated. The separate accused in the CID case, separate accused in the CBI case, and the whole case is based on one confession of a co-accused one. The whole case one. And they are trying to, from the very beginning, they are trying to rely on that confession also. As they are no material. Today also, now they are also says. Now, first of all, I'm just replying. This is an absurd proposition laid down by the council. First of all, they are saying then the trial court ought to have been considered that these material, the confession will be during the trial. But my respect to submission, that's not the stage, because the trial court at this stage cannot, on the basis of some anticipatory evidence, that tomorrow there may be some evidence will come and support the case of the prosecution, cannot frame the charge. In 1971 itself, our High Court, Justice D.M. Sen, his very landmark judgment has clarified that proposition in 1971 itself. that the anticipatory basis on the basis of anticipatory evidence or hypothetical proposition, you cannot frame charge that tomorrow there may be some material will come. The court has to frame charge the whatever material is placed on that particular day, not the some material which may or may not come. So their case is that tomorrow they may file a 311 petition, but who will come, my lord? 311 for the witness. He is an accused, my lord. The basic conception is wrong. 311, he is already an accused. He cannot be called for an accused because that statement will definitely go against him also. How he will, why he will come and depose in 311. The moment he will depose, he has to again face the charges. Already he is facing the charges in the other case. The 311 moment he discloses that I am in 11, the court is bound to make him an accused again. If that is be,
So, what is the outcome of the proceeding before the juvenile board?
he has been exonerated.
Exonerated
Yes,
for want of evidence.
want of evidence. Because his only evidence is that his own confession. There is no material apart from the confession.
Do you have the judgment?
There is no, because that is the order of the board, juvenile board.
No, that order is available with you.
I'll see my, right now I don't have file.
Okay.
But he has been exonerated as far as my.
And that's all right. You
Yes.
can produce that.
So my lord, whatever my lord, the fact remains that he is accused at this stage.
Mm.
So can the co-accused can be called as his statement, if his statement cannot be taken into account
Mm.
unless there is a joint trial.
Mm.
His statement only can be taken into account when there is a joint trial, section 30. So they are saying that we can rely on his statement prior to the joint trial in the 300, by invoking 311. 311 is a far long procedure, my lord. During the trial it will come. And you can call any witness, but not as an
No,
accused.
all right. I don't think that argument will advance her case. Let us forget about it.
Yes.
You come to the impugn order now.
So my lord, impugn order, this is the, now, apart from that, the 164 statement, will also lordship will find. He said this is a 164 statement, but this is a confession statement. The 164 and the confession are different, my lord. Confession, there are certain procedures to be followed while recording the confession, my lord. So while you record the confession, the sufficient time has to be given to the accused.
No, who recorded the confession?
Magistrate, my lord.
Magistrate.
So
Whether the formalities were observed?
no, all the formalities are not his reflection on that particular day. Because there are two parts, my lord. The first of all, he will remanded to the judicial custody. Then again, he will be called for after a few days, the remand period, calculating the remand period. Then on that day also, he has to be given reflection time. On that day, there is no reflection time was given as per the order sheet is concerned. So in the 164, he was brought in the 1 o'clock and his statement was recorded at 1 o'clock itself. That means there is no reflection time was given. As part of the High Court, there is a memorandum also, memo also of our High Court, and there is a judgment of our High Court that on that day also.
No, that's all right, but those parameters are to be tested only at the end of the trial.
Yes,
Not
but even then, well, I'm saying that they are trying on to the harp on that this is the statement. But that is the statement. Confession also cannot be taken into a confession because the procedure was not followed. Even we can consider, that is my argument, when we consider that statement also, that cannot be taken as a consider. There's no value in the eye of law, which has no value in the eye of law. It's not a piece of paper, my lord. They are relying on.
Okay.
So, and the impugn order. Lordship kindly sees the page 9. Sorry, madam. The order of our High Court, discharge order, madam. Paragraph. Order dated by law 10 to 2014.
Page number,
Page by law.
internal page of the order.
Judgment to page number.
Page number
24.
Yes.
Page 20. Running page 24, internal page 24. Otherwise 47 হবনি। আমার petitioner 47. 47, 46.
So, my lord, I may be permitted to read from my lord, the page 16, my lord, internal page 16, my lord.
No, is it necessary to go through the, you come to operative part?
Oh, yes, ma'am, that is that's from the operative part, my lord.
No, you see operative part starts from page number 24.
Yes, ma'am, but
Second paragraph, going through the statement of the witnesses
Yes.
examined by CBI.
yes. Going through the 24, my lord, the first
Yes,
one.
yes.
The above statement obviously cannot be regarded as incriminating material to lay the culpability of on accused Ripun Bora because making a mere request to a formidable T tribe leader of the locality to join the Congress party cannot be said to be a request to be looked with jaundiced eye. Going through the statements of the witnesses examined by CBI, it is found that none has said anything against the accused Ripun Bora or Pulil Pukun to indicate that they were involved in conspiracy and murder of Daniel Topno. The police officer Ann Singh has stated before the investigating officer that accused Kale Mijal was picked up by him during the investigation of the case relating to the murder of Daniel Topno. And during his interrogation, Kale Mijal reportedly stated before Mr. Singh that Ripun Bora had instructed him to eliminate Daniel Topno since he did not accept the proposal of the Joint Congress to refrain to contest assembly election. The further version of the police officer is that under political pressure, the statement of the Kale Mijal was not recorded and he was allowed to abscond. So the one police officer during the CBI interrogation, he said that he has heard from Kale Mijal that the Kale Mijal made a statement before him that I have requested Kale Mijal to eliminate Daniel Topno. The police officer coming with that statement. But surprisingly, he also said that I have allowed Kale Mijal to abscond. I have not recorded his statement also in writing. This is very strange for him. So he of his own come to a conclusion that why a police officer why he has allowed Kale Mijal to abscond and why he did not record the statement of Kale Mijal, why he has not apprehended, he should have been apprehended, he should have been forwarded to record the statement, nothing. He simply abscond. So court has found to be very absurd proposition, madam, and there is no corroboration to that effect.
And Mr. M.N. Singh was the investigating officer of CBI?
No, no.
Okay,
He simply he is one of the officers, madam.
okay.
Why he was called for and why no action was also taken against the NC also for the letting the Kale Mijal, who is the prime accused, why he's let him go, madam.
Mm.
The above statement of the police officer, now next minor, this is important. The above statement of the police officer cannot be accepted to be a strong material against the accused Ripun Bora mainly for the two reasons. The prime being that the confession statement made before police officer is inadmissible. Secondly, it appears from the record that during the relevant time, the said police officer was posted at Subdivision Police Officer Vishwanath Chariali, and he was supervising the investigation of the case regarding the murder of the Daniel Topno. From the record of the case diary, said that the Gauhati PS case number, it appears that nowhere in the case diary or his inspection notes, it has been mentioned by the state supervising officer about this purported disclosure made by the accused Kalemija, because he was investigating at the CID case matter.
Mm.
But in the CID case, though in the CBI case he's made the allegation, but the CID case, the same police officer absolutely silent, no record that he has interrogated Kalemija. He made a confession, Kalemija, no report, nothing. Very surprising matter. In his own investigation, he was silent about the implication by the Kalemija, whereas in the CID, he has implicated us. So that's why the court has found very suspicious and has discarded the statement of that particular answer.
Mm.
But it also revealed that during the investigation of the case by the Assam police, the statement of Kalemija was recorded, but in the said statement, this is again important, he has not mentioned anything that he was instructed by the accused Ripun Bora to eliminate Daniel Topno. Now, the same, again, Lordship will find, if we go by the Daniel Kalemija statement in the CID, he has not implicated me. Whereas the Mr. N. Singh comes in the CID that he has implicated me. Both cannot go stand together, my lord. The whole thing is very suspicious. It's just they have implicated me by making some false allegation, my lord, false material. They want to try me, so they have created the evidence. When you create the evidence, definitely it has to fall. Because this is not a natural. You are creating the evidence for the first time. So in the CBI has called Mr. N. Singh. The NC has implicated without recording the statement of the Kalemija. He's let him go to abscond. And he is the person who is investigating the CID case. In the CID case, there is no GD entry regarding the statement of the Kalemija. If we go by the Kalemija statement, nowhere Kalemija implicated me. So there is no material at all. It may be mentioned here that the Kalemija was search sheeted CID was not examined as a witness by the CBI. So though if the Kalemija has made a statement, he ought to have been the witness in the CBI. The CBI has mentioned in their search sheet that the allegation made against the Narayan Gaur and the Kalemija in the search sheet filed by the CID could not be substantiated by the investigation by the CBI. So if the Kalemija made a statement that I have eliminated so-and-so at the request of Mr. Ripun Bora, but the CBI, their search sheet said that we don't have any material against the Kalemija to prosecute. How can it be? It can't go together, my lord. One way you'll say that the Kalemija has implicated and he has committed the murder, and one way you'll say, no, we don't have material against the Kalemija. It is well settled principle of law at the stage of framing of charge, if there is no evidence except the confession of a co-accused, a charge cannot be framed on the mere probability of the prosecution that some future date, the prosecution might produce further evidence supplementing the case. A trial cannot be allowed to proceed on contingent, hypothetical, and anticipatory evidence. This Suresh Chandra Das versus State of Meghalaya, so and so. This is the case by our High Court in 1971 by Justice
DM Sen.
DM Sen. Very beautiful judgment, my lord. He has spent love. It's based on another Supreme Court judgment.
You have the copy with you?
Yes. Now, my lord, in the Suresh Vadarmal Kalani, Pappu Kalani versus State of Maharashtra, AI 1998, 3258, it also has been held while dealing with the question of framing of charge at the stage of court is required to confine to the attention to only those material collected during investigation which cannot be legally translated into evidence and not upon further evidence divorce those material that the prosecution may adduce in the trial. So, the Badarman Kalali also reiterated the same principle, my lord, that in future date, something will come and we have to frame charge. That's not the, now the, under section 30 of the Evidence Act.
You have already submitted on that point,
Yes, ma'am.
30, section
30,
30.
yes, ma'am. So that has been relied by these are the judgment, my lord.
Okay.
These are the judgment we have relied for the section 30. Now, likewise, last line of page 6. Likewise, in case of Soma Chakravarti versus Supreme Court Censor, it was observed that before framing of charge, the court must apply its judicial mind on a material place of record and must be satisfied that the commission of the offence by the accused was possible. Charge may be although be directed to be framed when there is existed strong suspicion, but it is only tried that the court must come to a prima facie finding that there existed some material. Therefore, the suspicion alone, this is very important, the suspicion alone without more cannot be basis of, therefore be held be sufficient for framing of charge. So only the suspicion will not do, my lord. For framing of charge by the Sessions Court, the strong suspicion is required. Now, Lordship, I'll just place few of the judgment to support my argument, my lord. The first, my lord, I have given the my lord. All citation compilation, my lord. The first one, the power of the court to frame charge under section 227, TRPC, grave suspicion is required. There are three judgments I have relied on, my lord. I'll not bother. There are three judgments we have relied. First three, I have also marked the relevant paragraph, my lord. Lordship will go through. Next one, the co-accused must be charged and tried together to rely upon confession against other co-accused, my lord. So we have relied on 5 judgment, my lord. Basically, Lord, judgment number 1 and 4. In these 2 cases, charge has been quashed, 1 and 4, because of co-accused not tried in the same trial. So his case 1 and 4, my lord. Next one, my lord. That's very important, as I have already argued, my lord. The court cannot start with the confessional statement, my lord. As I have already argued, my lord. First, this is very important judgment was the number 1, the Kashmir Singh's judgment. Then Haricharan Kurmi, my lord, very famous case, my lord, 1964 Supreme Court. Then the Surinder Kumar. It says, my lord, you cannot start with confession. First of all, you have to place your own material first. Then only you can rely on the confession. Now, number 4, the use of exculpatory statement, my lord. Here also, as I have pointed out, the statement, if we go by, he has not implicated. He is not privy to the offense, my lord. He wasn't making a statement, not making a confession of guilt, my lord. These are the 4 judgments. Then the presumption of the fact on the basis of another presumption. As I have, this is again the Suresh Badarmal Kalani, the famous judgment. It says, presumption cannot be based on another presumption. Here, whole case is rest upon the circumstantial evidence that because of I have requested him to join my party. That is one thing. And secondly, that if he contests, tomorrow there the whole material whole vote will come to me. That is another presumption. So there cannot be 2 presumptions. Presumption has to be based on at least one fact. Here they are relying on both the presumption. Now the charge cannot be framed on the basis of anticipatory evidence. That you will find the page 9. This is very beautiful judgment in 1971 itself. Page 197, Lordship can read.
Yes.
Paragraph 9. My lord. May I read, my lord? That's your lordship. The law is therefore quite settled that although the confession of a co-accused can be taken into consideration and can be regarded as evidence, it cannot be treated as substantive evidence. It can only be looked into so as to throw light and grave assurance to the other substantive and independent evidence. In other words, there must be substantive and independent evidence connecting the accused with the offense charged against him, and only thereafter the confession of the co-accused can be taken into consideration to throw light or to aid in the appreciation of such substantive evidence. Where the only evidence before the learned magistrate was the confession of the co-accused, there would, in my opinion, be no legal evidence whatsoever warranting the framing of charge. A. Sharma organization of state of Meghalaya has argued that even if this be considered that the state of framing of charge, there is no evidence except the confession of the co-accused. The prosecution might, before further evidence of an independent kind, to substantiate the charge. In other words, it is not close to the prosecution to bring to further and the better evidence. In the view of the matter, Mr. Sharma submit that the charge would not be quashed at this stage. The submission, however, does not impress me. If this submission were to be accepted, in every case, there would come for the quashing of the charge of under section so and so. The prosecution could contend that although the evidence or materials at this stage before the court might not be sufficient or even non-existent, the prosecution could subsequently add other material evidence, and therefore the court should not, in anticipation of such subsequent position of, if the accused would make in section so and so a completely negatory, when an application is made under so and so, a criminal PCA court is required to consider whether an existing material before the trial court, a charge could be framed in consonance with the principle laid down in so and so. All the documents which were before the learned magistrate at the time of framing of charge has been placed before me, and I find apart from the confession, the co-accused implicating the accused petitioner so and so, there was no other evidence in connecting him with the charge preferred him. To allow the trial to continue when manifestly there is no legal evidence before the court on the mere probability of the prosecution at some other further date supplementing the case by adducing further evidence would be, in my opinion, constitute undue harassment of the accused and violates the principle of law. So, a trial cannot be allowed to proceed on contingent, hypothetical, and anticipatory evidence. It may be further be noted that the accused has been facing the trial so and so. So, thereafter, my lord, this judgment has been again reiterated by our High Court in 2008, my lord. Then 2019 also, the Supreme Court. 2008 again, the same has been relied in a case of H.I. Chaudhary versus Rakibul Hussain. Then the Kalani also relied, and 2019 also same principle is relied, that on the basis of anticipatory evidence, you cannot frame charge. Then the re-evident evidence and the further investigation of important matter. Then so these are the judgment matter I have relied. So basically, they're harping on the co-accused statement matter. There and the stage matter. So as we are not facing the joint trial, that cannot be taken into account. But that's all much.
Yes, Madam, any reply?
Yes, your lordship, with regard to the procedure not followed.
Yes,
by-
Talukdar, same. You are adopting the, okay, all right. All right.
My learned friend has said that no procedure has been followed while taking the 164 statement. To that effect, I have certain reservation. The procedure has been followed and it has been reflected in it is already there on record. And the accused, namely Sri Kamal Nath, is brought before me on 15/5 by I.O. A.V. Gupta at 2 p.m. to have his confessional statement recorded. I have ascertained that the alleged offense punishable under section so and so. I have asked the accused to detail relating to the relating to his detention after arrest and stated that he was shown arrested at place Kamrup at 2 p.m. and detained at place of detention Gauhati jail for about 168 hours. Reflections time has been given to him and the procedure has been followed from 27/4/07 to 3/5/07. This is the time reflection which has been given to the accused juvenile and which has been duly followed by the magistrate at that point of time. Special judicial magistrate Srimati Mallika Datta was there. She has duly followed and given the certificate in the last page also with regard to the following of the procedure, Your Lordship. So
Okay.
there is no deviation while recording the 164. All procedure has been followed. Mhm.
But this confessional statement was recorded after 6 years.
Yes, because on filing of the writ petition, the matter was transferred to the CBI. And only on the behest of the CBI and during the course of investigation, CBI felt that his statement is required to be recorded. And thereafter, because of such reason, there is a delay. It was initially the state police PS, then gone to CID, and later on by filing a writ petition, it has come to the
No,
CBI.
when the case was handed over to the CBI,
It was handed over to the CBI. I am coming to that. The charge sheet is filed on criminal petition, 10 February, the Dalit Trial Court discharge. There is a WPC, Your Lordship, I am coming to that. Hmm.
17/5, my lord. 17/5/2005.
Yes, 17/5/2005.
and after how many days of handing over the case to CBI, the confessional statement was recorded?
That I am coming.
2 years.
It is on 29/5/2007.
29/5.
2007. And the charge sheet is filed on 30 December 2008.
Okay. Heard Miss M. Kumari, learned counsel for the petition.
Complainant.
She said that the confession time was given. I am not on the first stage. I am then when he was again produced.
Yes,
It was not on fifth. Fifth he was given the sufficient time.
Yes.
But again when he was produced, on the date when the confession was recorded, on that day itself, there has to be reflection time has to be given to the. So on that day there is nothing. He was produced at 2 o'clock. He was recorded at 1 o'clock, and he is recorded at 1 o'clock as per the confession itself.
Okay.
No time has been given.
No time.
And these are the facts which has to be tested in the trial court during the course of
Okay, I
trial.
will say.
And at the stage of
will say.
framing of charges, only the prima facie case has to be taken into account, Your Lordship.
And also heard Mr. M. Gora.
Complainant would like to submit certain judgment. Could be, sir. He is not present, complainant. Unable to say. He has produced certain judgment.
What to do? He is not present today.
No, he
Yes,
was
madam.
present. He was present. Just now he went. Put a stick on him. Could you at least say this, sir?
Okay. Okay, let him file it to the court master.
Okay, I will compile it and then I will file before the court.
And also heard Mr. M. Gora, learned senior counsel, assisted by Mr. Yes, your good name, please. D. Gogoi, learned counsel for the respondent number 1.
Wow, that's one.
And Mr. Talukdar, learned senior counsel, assisted by learned counsel for the respondent number 2. Argument concluded. Judgment reserved.
I have given the all these statement also. All details of it. All right.
And this I am filing in due course of
Okay.
the day. Ahile, teo ahile. Iba ko bolo ba sa?
Mr. Bora, you are for the complainant. Mr. Bora for the respondent number?
Come here, come here.
Respondent number.
1 minute, 1 minute.
Okay.
Right now, I have nothing to say, my lord. I will adopt.
Submission
submission,
of
But
M.
the
Kumar.
judgment you
All
would
right.
like to.
I have to place some judgment. my lord.
Okay, you can furnish it to the court master.
File.
Yeah, click it, the complaint.
Items for motion.
Okay.
Item 20. Obligation.
Click it for myself.
Item 24.
Yes.
Which is a lordship. This lordship, I find a revision challenging the order of the district judge lordship, which is an annexure 12, annexure 12, page 94. The district judge by the impugned order upheld the order, and then point is he did not consider the essential points. Only point for determination was whether it was a public premises. And that too also, lordship, the district judge failed to consider the papers I have put forward in the fact that I said that I have a holding number, I pay revenue to the town committee, and also I am a Jadavrai, that land form a part of the Jadavrai grant. Railways came up with a map, a site plan, and the court held that this site plan, the Guwahati High Court has also held that the site plan is good enough to establish the title of the railways. Be that as it may, even otherwise, lordship, I had a license from the railways. I had a license. My license was cancelled and I was asked to vacate. But even thereafter, a Section 4 notice is mandatory. The learned court below did not consider whether a Section 4 notice is issued. I have been residing there for about 50 years. And now all of a sudden, you take with the summary proceeding, you seek to evict me. Lordship, there must be some sense of semblance of justice, some sense of natural justice being followed. And in fact, the Supreme Court has also said, Lordship, I'll just rely on the Supreme Court judgment in 1977. The Supreme Court has said that license, even after the appellant remains in settlement after the license is expired, even then a Section 4 notification is mandatory. Lordship, on this count, I have come against this judgment. I will show Lordship how even that I am not a public premises. It's not a public premises. The state has Karbi Anglong Autonomous Council has not even produced a revenue map before the authority. That was the least he could have done, was verify the revenue map. If my primary objection is that Section 4 notice has not been issued.
Okay. Mr. Gogoi, so the primary contention of the petitioner is that notice under Section 4 has not been served. Do you have any document to show that it was served?
Yes, duly served, proceed. So for that purpose, whether notice is served or not, proceed. If my senior name is finished, then I can place a meeting place.
Lordship,
You
it's
can?
not there on record. Even the district judge,
You can?
After finishing my senior, I will place a meeting.
Okay.
even the district judge did not consider in his judgment when he's supposed to see a Section 9 appeal, what he's supposed to see, whether Section 4 notice has been served, whether hearing has been given. What had happened, Lordship, I'll say, in 2000, this exercise of evicting me was going on from 2014. In 2011, my license was renewed, and sometime in 2015, I was given that my license has been cancelled and you were asked to move. And thereafter, there were some letters, we had moved some association moved this honorable court. Thereafter, 2 letters were issued, that was in 2024, by the revenue, saying that steps are to be taken for eviction of these people there are a lot of people who are in the bazaar for eviction. So when that letter came, again a batch came and approached before this honorable court. This honorable court quashed. Our consistent ground is that this is not a railway land. This honorable court quashed those letters and said that you make a representation to the estate officer. So we made a representation. Now, on our making the representation, the estate officer passed an order Lordship, which is at Annexure 10, page 80.
Yes.
Lordship, he passed the order that was hearing on the representation. This was on the representation which was filed by me.
Hmm.
Then Lordship will come to page 81. During the hearing, the opposite parties univocally admitted that the subject plot belonged to the railway administration. He further conceded that he has been occupying the land in question without any authority or approval, which is wholly incorrect or valid permission from the railways. The opposite party failed to prove any documentary evidence to establish that he is a lawful occupation of the said land. Submission of evidence by the petitioner railway. Petitioner railway submitted the former documentary evidence, certified land plan number this jointly signed by the railway authorities and the state civil authority, trace map and demarcation of the railway land issued by the state civil authority, Karbi Anglong, land detail near Bokajan railway station issued by the additional district commissioner and ARO, Fu Circle. The above documents irrefutably establish that the land in question is duly acquired by railway administration and falls under its ownership. Now, when it was acquired, we do not know, Lordship. The petitioner railway has stated that the land in question unregrettably required for the development of the work, specifically for the construction of the road under bridge near the Bokajan railway station. The unauthorized occupation of the land by the opposite parties is causing an obstruction to this critical infrastructure. Finding and decision. Upon careful consideration of the submission made by the parties as well as the in-depth examination of the records and evidence present, the following findings are as made. Land in question constitute the public premises as per this and this. The opposite party is an unauthorized occupation of the railways and has no legal right, title, authority. The railway require the land for public infrastructure and protection, and the unauthorized occupation is impeding the same. In light of the above, I am satisfied that the opposite party is liable to be evicted under this. Accordingly, the powers vested under this, I order eviction of this. So even if here there's no mention. Now, Lordship, this is also wholly incorrect, this order, because I will take Lordship to the license which has been issued to me. License was issued to me, that Lordship will find. That is Annexure 3.
1976. We have
No, license was cancelled long back in the year 2015,
That was in 2015 for some.
but you have not challenged it.
No, Lordship, that was challenged in the best. Then nothing had happened. Lordship, in this case, Lordship, I have not challenged that. They had asked me to move.
No,
Thereafter,
the cancellation of your license.
thereafter, Lordship, nothing was done. We came to the High Court. Nothing was happened. They took no steps for evicting me. I kept on paying my holding fee. And in this case, Lordship will see there's a letter. This is a 76 letter, of course, at Annexure 3. As applied for, the railway administration is page 26, Lordship.
26.
Yes. Regularize your honor occupation by granting proper license under the following conditions. You should clear up your entire area dues as calculated below. You should be in readiness to remove your structures from the present site if the same is found not sparable from the railway side, and recite the same at any other alternative site as will be available and offered by the railway. No pakka structure shall be shall be allowed to be allowed. Reconstruction of the structure should be only done as per railways plan, and so that's it. So this is it. They agreed, they allowed us to settle, and we were paying. That was the case of everyone. Now, whatever it is, Lordship, even if my license is cancelled, I'm still entitled to Section 4 notice. Where is that notice? Neither this district judge talks about the Section 4 notice, nor do the estate officer. The Section 4 notice we have not received. It's just a small notice. Hear me. That is my valuable right. How can you evict me directly without a Section 4 notice, Lord?
Okay, okay,
Which is a mandatory provision. That is the primary question.
okay. Okay. Mr. Gogoi,
I will attend
Uh,
that
uh,
particular issue also.
we are not finally hearing the matter today.
No. We are not finally hearing the matter.
Okay,
Only
Uh,
if there
then
be the
let us
issue,
fix a date.
Lordship may fix a date. I don't want to
If
delay it
there be the
also.
issue, Lordship, I can place that particular person right now itself, Lordship. So Lordship may kindly give me 10 minutes time, Lordship. I'll place everything. Lordship.
No, that's all right. Mr. Gogoi, you see, today we are not finally disposing of this matter.
Lordship.
On the day of hearing, you can argue, you can place anything
Notice
you
is
would like.
already served, that's why, Lordship, this petition
No,
is
no.
not maintained at this stage, Lordship.
Notice?
Notice is already served, Lordship.
What if?
I will place it, Lordship.
Notice?
I will place it by this documents, their petition, I will place it, Lordship.
No.
I will place it.
Hmm,
So Lordship, give me 10 minutes, otherwise it's a 227 petition, Lordship.
hmm.
There is no any jurisdictional error, Lordship. There is no any.
No, that has to be examined,
Let us
whether it is
examine.
there or not.
Lordship. So Lordship.
Let
So,
him file an
let us
affidavit,
do
place a
one
notice.
thing.
If it's not required, here is a civil division petition, Lordship.
Hmm.
Let him file an.
Go by the document, Lordship.
Hmm.
Just now I satisfied regarding issuance of notice point, Lordship.
No, no. Mr. Gogoi, you see, that's all right.
Yes.
But today we are not finally disposing of the matter.
Lordship.
Let us fix a very short date.
Lordship. Otherwise, Lordship, the railway project is there, Lordship.
Yes,
Railway
we'll
infrastructure
fix a
project,
very short date.
infrastructure project is there. So,
That is
Lordship,
there.
regarding notice part, I will just, Lordship, 5 minutes, Lordship, give me. I will notice whether notice was
Okay.
served or not.
Okay.
There are basic cases on the basis of the whether notice was served or not, Lordship.
Hmm.
So, Lordship, here, my lord, may kindly peruse page 47 for a moment. It's a repetition,
Hmm.
referred by lordship. Almost lordship 32 repetitioner.
Hmm.
Real number 7, my lord may kindly mark it Subhamoy Bonik.
Hmm. He is one of the read petitioner.
He is one of the repetitioner. In that particular repetition, page 47 lordship, serial number 7.
Hmm.
Then my lord may kindly come to page 51, paragraph 3 lordship. The petitioners hearing claim that since 1970 onwards, they have been in occupation respective plot of land of ward number 4 in Bukazan, thereby running their livelihood of their families through stationery, grocery, medicine, tea stall, hardware, photo shop, photo studio, so and so. Then my lord may kindly come to in the year. Next 5th line, lordship.
Hmm.
5th line.
Hmm.
In the year 2011 and 12, notice were issued under section, it is the petitioner's case.
Hmm.
In the year 2011 and 12, notice were issued under section 4 of the public premises eviction of unauthorized occupants act 1971, asking the petitioner to show cause as to why they should not be vacate the land in their possession as the same fell within the ambit of the public premises as defined under section 3 of the 1971 act. The material on record present so and so does not show the petitioner as well as other persons whom notice were issued have submitted any reply. My lord may kindly mark that particular portion, lordship.
Hmm.
It is the admitted case of the petitioner that lordship in 2011 and 12, notice were served under section 4 of the public premises authorized occupant act. Since 2011, the matter was going on. Then my lord may kindly come to paragraph 5, page 54, lordship.
Hmm.
Page 54, it's paragraph 5, lordship. I will not read the first para, then my lord may next page lordship. Starts from second line. The learned district judge in dismissing the Miss Civil Appeal so and so. It was also opined that the society where the petitioners hearing where the members cannot be affected and necessary party in the proceedings before the court. The learned district judge that the eviction order was not issued to the petitioner but to the individual person. My lord may kindly mark it. Here the miscase was filed by the society who was formed by the petitioners. That miscase was dismissed by the civil judge. But to the individual persons who have not made to challenge the same in terms of the section 9 of the Act 1971. My lord may kindly mark it. Then my lord may kindly come to paragraph 7 at page 56. Lordship. Page 56. Lordship.
It's a wrong page. Wrong page.
Page 56, paragraph 7. Lordship. This is the summation of the petitioner's counsel at the relevant point of time. The one of the here civil division petitioner is a petitioner number 7. Mr. So and so learned senior counsel appearing on behalf of the petitioner submitted that there has been no adjudication on merit either by the appellate authority or by the court where proceedings were filed. He further submits that the petitioners hearing did not get any opportunity for submitting their replies to notice issued under section 4 of the Act 1971 is as much only some of the persons who are residing over the lands and received the notice. My lord may kindly mark it. Then my lord may kindly come to paragraph 13 at page 60, lordship.
Yes.
In the backdrop of the above, let this court analyze the factual metrics. The materials on record show that the petitioners herein were duly issued notice under section 4 of the Act 1971. My lord may kindly mark it. There are allegations and counter allegations to the effect that some of the petitioners did not receive the notice and some have. The fact that petitioners did not submit the reply to the said notice is not in a question. My lord may kindly mark it. Be that as it may, orders were passed under section 5 of the Act 1971. This court during the course of the hearing had the occasion to going through the orders passed by section 5 of the Act 1971. The said orders, however, with defeat of any reasons, assigning reasons to an order by a quasi-judicial authority, befalling civil consequences, not only be the tune of the principles of natural justice, but also necessary for the purpose of clarify fairness, understanding, objective, so and so, so and so, so and so. It is also dispute, not a dispute, it is the findings of the honorable court that lordship. Notice was duly served to the petitioner and they have not replied to the notice. Then my lord may kindly come to page 16, paragraph 62.
Yes.
This court further takes note of that petitioners herein are now aware of the notice under section 4 of the Act 1971 were issued to them. So and so the learned senior counsel for the petitioner also submitted that in view of the passage of time and the litigations, the notice under section 4 of the Act 1971 can be deemed to have been issued against the petitioners also. My lord may kindly mark it. He submits that the petitioners have right to resist the summary eviction proceeding on the ground that the lands under the occupations are not public premises as well as rising the bona fide dispute. Learned senior counsel for the petitioners therefore submit that the petitioners were permitted to file the individual representation. What's remain, lordship?
But lordship, this
What remain, lordship?
I
I have not finished.
Oh, sorry.
I have not finished. What remain, lordship? The main contention is that section 4 notice was not served to the petitioner. It was the case of the petitioners that section 4 notice was duly served to them. They have not filed reply. They should give an opportunity to represent them against the so and so, so and so. On the basis of that, lordship, the honorable court directed, the direction is page 18, lordship. Paragraph 18, page 63, lordship. Accordingly, the instant repetition instance dispose of the following observation and decision. The order so passed their order, that section 5 order was, it was decided and quashed. Then petitioners herein are given liberty to submit individual representation to the respondent number 3 within a 10 days from the date of instant judgment. In this said representation, the petitioner will be able to raise amongst other issues to the effect that the land in questions under the occupations are not public premises so and so so and so. In doing so, petitioner would have submit the substantial at the basis of the relevant document. Upon submission of the said individual representation by the petitioner, respondent number T is directed to decide the dispute by giving an opportunity of hearing both the railways and the petitioners, either personal hearing or hearing for their authorized representative, so and so so and so. This is the directions of the honorable court, lordship. On the basis of that, lordship, the page 80, lordship. That section 5 order was passed, lordship. Reasons is there, lordship. The order is there, lordship. Even but their representation they have also represented, lordship. They have also represented. If lordship permit, I can read the order, lordship.
No, not necessary. The C has already read it.
And my lord may kindly come to the judgment, lordship. Lordship. 12,
Trial court.
lordship. Lordship.
Okay, you complete your argument.
May I complete?
Yes, continue.
Lordship. Then my lord may imping judgment, lordship. It starts from page 94, lordship.
No, you are not required to read the entire judgment. Come to operative portion.
Okay. For that purpose, lordship, I have to place that particular paragraph. I have to place, lordship, more than 10 paragraphs, lordship.
No, not necessary. We will consider these paragraphs at the time of final hearing.
Lordship, the basic issue is that whether notice was served or not.
Mm.
It is already well settled. That was never
Notice was served.
Lordship,
Notice was served.
notice was duly served.
Mm.
Notice was duly served. Their basic case is based on notice was not served. Notice was duly served, lordship. Even lordship, they are pleading also, lordship, not it. If lordship permit, I can place the relevant paragraph, then it will be easier, lordship. It will take at least 20 minutes time, lordship. So, lordship,
So let us then finally hear and dispose of the matter in the next week.
lordship,
Next week,
before that, lordship, we are facing some problem, lordship. Thursday, lordship.
Thursday,
Lordship.
Let them fine.
Thursday.
Thursday. That is,
There are some more matters where I'll show lordship that even in 2014, they say notice was served in 11. That has been abandoned in as much as in 2014, 11, license were issued.
Mm.
And in 15 only it was cancelled.
Mhm.
So that notice has no value over there. So those documents, lordship, those individual cases have to be looked into. You can't say any, even here, which is the notice. They went in the bulk and they made a statement, lordship,
Mm.
encompassing everyone.
Mm.
So my prayer before your lordship would be, if some time is given to me, I am, it's fixed. He wants on Thursday. If it's on Tuesday next.
Regarding date, I have no difficulty, even 1 month also, but the railway in first.
I know. I don't want the
They are
delay.
suffering this.
I don't
They are
want
the
the-
illegal occupants, they are admitted case, they are the illegal occupants.
No,
And
but
they have relied the document page 26. For a moment, my lord, kindly peruse. What is this, lord? Page 26. Their document. It's not my document, lord. Page 26.
yes.
Unauthorized occupation of railway land at Bukadan commercial use. You are unauthorized occupied railway land, so and so on. This is their documents, they have relied that particular document. Lordship. What's remain, lordship?
So then they say I'm regularizing. That's what I want to. So
They are
Tuesday
the
next.
unauthorized occupant, lordship.
Tuesday.
Okay. Thursday, my lord, may kindly take. I have the some paper, lordship.
Even I have a little problem, lordship. Let it be on Tuesday. I think 2 days will not kill him. Not kill railways. Lordship, railways are sufficient. And now
One time, lordship, the fund was came before this, before the railways, lordship, that was returned back. Again, that fund was, we are not able to utilize it, lordship, in 2025-26 also, lordship. Because that reasons, 2011 itself litigation is going on, lordship. We are suffering.
okay, then let it be on Friday.
Friday,
Yes.
not this Friday, lordship.
Then Monday.
Monday or Tuesday? Monday. Monday.
Go away. Monday.
Lordship.
Heard Ms. M. Hazarika, learned senior counsel assisted by
Hello.
Mr. So-and-so, learned counsel for the petitioner. Mr. K. Gogoi, learned CGC.
M. Devi, she's also there. She's also CGC person.
And also Ms. L. Devi, learned CGC for the respondent number 1. And Madam Bormon for respondent number? Respondent number 4. Any other party?
Lordship, I am for 1, 2, and 3, Lordship.
1, 2, and 3.
1, 2, and 3, Lordship.
Number 5.
5. Respondent number 5.
Yeah, copy we have not received.
Copy. Madam, you furnish a copy to her.
Copies.
Okay. List this matter on Monday for further consideration. Till then, interim order dated 28/7/2026.
Next to a same, Lordship. Next to a same.
Pardon?
There are two more.
Yes, same order.
Alam, make it the part of it. Make it the part.
Further consideration.
Oh,
Further.
But
Further.
hearing is personal.
First.
Number 7 was number 2 and 3. For the number 2 and 3, I was hearing Lordship. But
Okay.
on the last order of 8/26, Lordship. It is inadvertently that here it is that here for respondent number 2 to 5. Lordship. 4 and 5 Lordship is private respondent Lordship.
Okay. You are for respondent number 2 and 3. Heard, Mr.
Okay.
Learned counsel for the.
Extra copies are permanent. Next, respondent number 4 and 5 Lordship notice may be issued. Lord.
Lordship, notices have already been issued on all the respondents.
Heard, Mr. So learned counsel for the petitioner. Ms. Borman, learned additional senior government advocate for the respondent number 2 and 3.
Yes.
2 and 3.
Number 1 also appeared Lordship.
Pardon?
1 appeared Lordship in the
Appeared.
Yes, Lordship, by 5.
None appears for the respondent number 1 today. In view of the office note dated 1/6/2026, notice upon respondent number 4 and 5 are yet to be served. Accordingly, it is provided that the appellant shall take fresh step upon respondent number 4 and 5 by speed post and also by usual process within a week from today. Office note dated 8/7/2026 indicates that the record of title appeal number 1 and 1/2025 and TS number 1 of 2021 has been received. Let the matter after 4 weeks. You take step.
Lordship.
And Lordship, extra copy till that we have not also furnished extra
Okay,
copy.
Ms. Borman submits that she has not been furnished with a copy of the memo of appeal. The learned counsel for the appellant is directed to furnish a copy of the memo of appeal to Ms. Borman within 2 working days from today.
10 days, Lordship.
2 working days
Lordship.
from today. You effect service upon respondent number 4 and 5 by Dusty mode also.
Usual process.
No, by Dusty mode.
Okay, Lordship.
Additionally, Dusty service is also permitted upon respondent number 4 and 5. After effecting service by Dusty mode, the appellant shall file an affidavit before this court. Place the matter after. If you effect service by Dusty mode, then we will fix short date 2 weeks.
Lordship.
Place after 2 weeks.
Yeah, please, Your Lordship. Lordship, I have a small prayer, Lordship. Since it's a matrimonial dispute and also they are agreeing for mutual settlement, Lordship. If it is sent for mediation, there is a probability for an amicable settlement, Your Lordship.
Okay. Heard, Mr.
Yes, Lordship.
Learned counsel for the petitioner and Mr.
R.K. Mondo on behalf of P. Bordoloi.
R.K. Monto, learned counsel appearing on behalf of Mr.
P. Bordoloi.
A. Bordoloi, learned counsel for the respondent. It is submitted at the bar that this matter may be referred to the mediation. Yes, there is chance for settlement of the same before the mediator. Accordingly, taking note of the submission of learned counsel for both the parties, and this matter is thus referred to the mediator, Gauhati High Court Mediation Center. The mediator shall file a report. Put in, should I fix it that, Kobe? Put in?
3rd August, Monday.
No,
No problem.
long time,
Before it,
4 weeks.
4 weeks.
4 weeks.
Since the respondent is a resident of Dissonance Island, Lordship. So
20 August.
20 hours is fine. Yes. Deeply obliged, Lordship.
Item 9.
My lords, I'm appearing for the respondents in item 9 virtually, my lords. Am I audible?
Yes.
My lords, before my learned friend starts, my lords, I have a small request, my lords. My lords will notice that in the cause list, there are 2 items listed, my lords, CRP 65 and CRP 66. My lords, on the last date, my office had entered appearance in CRP 65 for respondents 4 to respondents 13. We've just received instructions, my lords, to also appear for the same respondents in the second CRP. So, my lords, we are in the process of filing our vakalatnama in the course of the day. And secondly, my lords, we've also filed the affidavit in opposition in CRP 65. I believe it has not come on record. It is going to come on record in the course of the day. I appreciate, my lords, there is urgency in this matter
You
from
are,
the side
you
of
are, you
the
are not
petitioner.
visible.
Sorry, my lords.
Counsel, you are not visible.
My lords, am I visible now? My lords, my request is to defer this matter and post it on a very short date, because by then, my lords, we will have filed the vakalatnama, and my lords will also have the advantage of our reply that we filed. And then, my lords, may kindly have this matter for final consideration.
Service in this matter completed.
In fact, the last occasion the matter was listed and the council's appearing, my lord, sought for some time to file affidavit in opposition, though there is no concept of filing an affidavit in opposition in CRP matter, because in the execution proceedings, the plain WS and all the pleadings are completed before the learned trial court and the executing court. So
lords,
by way of bringing,
If I may submit, my lords, it
let
is-
me submit.
All
You'll
right,
get
go
your
ahead.
time. So if the affidavit in opposition is filed, my lord, the pleadings, my lord, which has already been averred in the executing court by an objection, because we filed a 47 application against their execution proceeding, my lord. They filed an objection, and this is the pleading, part of the pleading. Affidavit in opposition will not be considered as a part of the pleading. Whatever they have stated, my lord, before this honorable court, it has not been looked into before the executing court. If they've added something new, my lord, we don't know, my lord. We have received the copy yesterday. And if they added something new pleadings they have brought on, but that cannot be considered by this honorable court.
Maybe we will consider the same at the time of hearing. Let us fix a very short date then.
Yes, my lords, I'll be very humbly obliged, my lords. In fact, my lords, the reason we had to file the affidavit in opposition, if I may indicate, is because the CRP that has been filed by the appellant does not disclose a lot of relevant information that were filed by us. For instance, the objections we had filed to their application is not even a part of their petition. I would submit during hearing that through pleadings they have suppressed information to prejudice the other side, my lords. Which is why,
All right. We'll consider the same at the time of hearing.
yes, my lords.
Mr. Discuss learned counsel for the petitioner. Mr. Your name, please?
Mr. Rangan Chaudhary, my lords.
Mr. Rangan Chaudhary, learned counsel for the respondent.
Respondents 4 to
Mr.
13, my
Daspa?
lords.
For 1, 2, and 3.
Mr. Das for 1, 2, and 3. Since the learned counsel for the respondent number
4 to 13, my lords.
4 to 13 submits that he has filed one affidavit in this matter, and the same has not been placed on record. And accordingly, he pays for listing the matter in the next week. Pair allowed, recess and list the matter. Suggested that Mr. Biswas.
My lord, can it be on 13th or 14th
August.
August?
Okay. 14th of August then. 14th of August.
All
Along
right,
with
my
the
lords.
CRP number, the item, along with the other item number.
CRP 66 of 2026, my lords.
Okay, 10. Okay, all right. Same order in 9 and 10.
Much obliged.
Much obliged, my lords. Much obliged.
Item 11. Lordship, by last order, Lordship direct me to address on the question of maintainability when there is no specific challenge to any order. Whether in circumstances, application under Article 2.7 is maintainable before this.
One another point I want to make. They have filed this case against the date for.
Lordship, I'll address to that also. Whether they have,
Revision petition has been filed against the date for.
yes, Lordship, correct. But whether they have do anything before the learned trial court, Lordship.
We have mentioned specifically in our.
No, no, no.
Before the court, that man died in the year 19.
I'll show from their document, Lordship, that still their application against this person also.
They filed their application in 26.
And if they file an application in 2026 in the name of that person also, even if they said that is expired in 2019. So their conduct itself shows that they are misleading the court. Not only the court, the plaintiff also. Lords.
So now we came to know about the demise of that person.
Lordship, their
Can
document
we
says,
proceed against him? No.
yes, Lordship, that is there. Lordship will decide on that point also. Lordship, first, Lordship, Article 227, this petition is maintainable before this honorable court when there is no specific challenge to any order. Probably this was the last order.
No, that's all right. But your application is pending before the trial court.
Which one, Lordship?
Your application is pending before the trial court.
Lordship, we prayed before the court that when the court has no jurisdiction, return our claim.
No, that order has not been passed.
Yes, Lord. No order has been passed.
Yes.
That's why we approach.
So the principle is when alternative remedy is
Yes, Lord.
available, petition is not maintainable.
Yes, Lordship, that is correct, Lordship. But in the present case, whether Lordship can invoke the power of superintendence, Article 227 or not, Lordship. Lordship, if Lordship allows me, I can submit on that point.
No. While alternative remedy is available, then this petition is not maintainable.
Alternative remedy is available to me, Lordship.
Pardon?
Because the court has no jurisdiction. In view of the division bench order.
No,
passed by
you
the
have
honorable
already filed an application before the trial court
Lordship, we have prayed before the trial court.
for returning the plaint.
No, Lordship, orally we have submitted, but in spite of that, Lordship, the trial court has fixed the matter for the question of maintainability on 27/7. When there is a, on the face of the record, when the court has no jurisdiction, whether court can pass such order.
No, that order is not impugned here.
Lordship, in my humble submission, that is not required. Because we are challenging because learned trial court has come to a conclusion that this honorable court has no jurisdiction. to entertain a commercial suit in view of the judgment passed by this honorable court. And we rely on notification that has been set aside by the this honorable court. Lord, may please to see.
Mr. Poddar, you were appearing for,
Response number 2 and 3, Lordship.
you were filer color number
Yes, Lordship, yesterday I filed by.
yesterday.
They file also caveat also.
I have kept it only for the response number 2 only, Lordship.
Lordship, their conduct itself shows that
The authorized secretary of the response number 2, Lordship.
regarding Lordship date partition, their conduct shows that in 2026, they file application in that time before the trademark authority Lordship. And on the other hand, they said that the person died in 2019. So their conduct Lordship shows that they are misleading the court, honorable court. Lordship.
Mr. Kayal, the case before the trial court was fixed yesterday,
27.
27.
Of this month.
So I think it is better to wait till.
No, Lordship, I'm not on, but regarding Lordship jurisdiction of this honorable court, Lordship on last occasion, Lordship directed me to address on this point.
No, that's all right, but it is well settled that whenever alternative remedy is available, you cannot maintain this petition.
Lordship, then our petition will be in process, Lordship.
Maybe.
But Lordship, this is not alternative remedies.
Which one?
We
You
have
have
not,
already filed an application there.
no, Lordship, we
Petition is
already
pending
paid.
there.
We have not filed any application. Lordship, land trial court has come to conclusion, Lordship. Concept of present. I'm showing the order, Lord.
There is no conclusion, Lordship, trial court. We have raised the issue.
Lordship, may please to see the order passed by the land trial court. Probably my land friend is not aware about all these things.
At page number?
Lordship, I'm just. Lordship, what happened? A commercial suit was filed by us before the London district judge. That was returned to us that there is a notification that the suit lie before the London civil judge. Then Lordship, initially, London trial court entertained our application and granted anything injunction. But finally, it was rejected. And page 267. Married, order dated 29/5/2026. Page 267. The order is passed in commercial suit number 52 of 2026. Order dated 29/5/2026. Both the parties are represented. The case is fixed for admission and denial of documents. On perusal of the case record, it is evident that on 28/4/2026, when the defendant filed the written statement, they have raised the issue that this court has no jurisdiction to try the instant suit, as the same is filed for various provisions of Trademark Act 1999 as a commercial suit. Hence, the plaintiff is liable to be rejected under Section 7 of 2011 CPC or to be returned under Order 7 Rule 10 of CPC for presenting before the court of honorable district judge having proper jurisdiction of the case. In this regard, they have also submitted that the Honorable Gauhati High Court by judgment dated 18/12/2025 in case of Brahmaputra so-and-so versus so-and-so in FA number so-and-so dated 13/2/2000 issued by the Judicial Department of Assam would not have effect whatsoever, being known as in law in the eye of law. In view of the above, judgment and notice dated 13/2/2019 issued by the Judicial Department, Government of Assam, in exercise of its power under Section 3 of Commercial Acts to designate the Court of Civil Judge under Gauhati High Court, its commercial court was cancelled, though the case was fixed for admission and denial of the document and the parties. I am consider opinion here that the parties regarding contention raised the defendant regarding jurisdiction of this court to try the suit prior to further proceeding in this case. This is the order. And Lordship, it is specifically of the defendant in WS that the suit is not maintainable for these two reasons. And Lordship, we have annexed this notification and order of this honorable court also.
No, the trial court has yet to take a decision.
Lordship, my contention before a Lordship, when the expressly the trial court has no jurisdiction, and this is the plea of the defendant in their written statement.
No, that's all right. Trial court has not yet taken a decision on that point.
Lordship, for my satisfaction, Lordship may come to page 269. 269, next page, annexure 9. This is a
No,
not-
in this notification you have already shown to
No, no,
this
this is
court.
a notification
on the
and this
other
is
day.
the next page is the order of this honorable court.
Hmm.
Thereby, Lordship, this court has held that this notification
Hmm.
dated 13/2/2019
Hmm.
is non-extant law. So what is to be decided by the learned court is on our client, Lordship, and simply we prayed before the court that the prayer of the defendant may be accepted and our client may be returned to present before the honorable the proper court of having jurisdiction. And Lordship, any order passed by the trial court
Hmm.
which has no jurisdiction, whether it is a proper order or Lordship, under the facts and circumstances of the case. And we are hanging in the balance, Lordship. Neither we can challenge the order nor we are taking any decision unless the plaintiff is returned.
You wait till 27th.
That is all right, Lordship.
Hmm.
But Lordship, we filed application on 27th of June, Lordship.
Hmm.
And there was a intervening vacation period that this honorable court fixed the case on 13th, Lordship.
Hmm.
Expressly when the court has no jurisdiction and this is the stand of the defendant also, that
No,
suit is not
if
maintainable.
the trial court decides to proceed with that case, then a case for interference under Article 227 is made out. Now
Lordship,
the matter is pending before the trial court for decision.
correct, Lordship.
Hmm.
But my submission before Lordship, when court has said that court has no jurisdiction in view of the judgment passed by this honorable court,
Hmm.
Lordship, whether proceeding can continue, Lord, even if Lordship.
No, it has not continued with the proceeding. It has simply fixed the matter for hearing on the point of maintainability.
And Lordship, another point before Lordship is for submission, my submission, that on the same day, my injunction petition was taken up by the learned trial court and it was rejected.
No, you have not challenged that order.
No, Lordship, yes, Lordship, we have challenged the
If
proceeding.
you challenge that, we can consider it.
No, Lordship, probably this order is non-extant law.
Yeah,
And the court has no
your
jurisdiction.
verbal submission will not act upon it. Let it be after 27.
No, Lordship, this is the situation, Lordship, I placed.
Maybe. Maybe.
Then Lordship, my petition may be converted into 226. Lordship. Because the Lordship has power to, may
No,
be
no,
converted into 226.
no.
Because
No.
this power has. Supreme Court-
Better you can withdraw this petition and file whatever petition you like.
No, Lordship, 226, Lordship has power to convert.
No,
into
no.
226.
No.
Then Lordship, my submission may be recorded and the Lordship may pass any order. Lordship.
No.
No.
Okay, heard Mr. Kayal, learned senior counsel, assisted by Mr. Zain, learned counsel for the petitioner, Mr. Putta for the respondent number 2 and 3. And Madam Burman for respondent number 1. After hearing Mr. Kayal, learned counsel for the petitioner, and having perused the order dated 29/5/2026, this court is inclined to adjourn the matter till till 29th of July 2026. Since the issue of maintainability of the title suit,
Commercial suit.
commercial suit number 52 of 2026 is pending before the learned trial court. List accordingly.
Lordship, with my prayer regarding Lordship converting petition to
Sorry.
Article 226. Lordship, please to observe Lordship because
No, sorry.
Lordship, in this case, the service is complete. Respondent 1 has appeared. The matter may be fixed for admission.
Okay. Heard Ms. Tode, learned counsel for the petitioner. And Mr. I Ahmed, learned counsel for the sole respondent. Since service in this matter is completed, this is list the matter for admission after August.
They have been struck off, 2 and 3 have been struck off.
Okay, okay. Okay, exited in the month of August.
Lord, there's an interim order which is
Interim order pass earlier shall continue.
obliged, Lord.
Service report is awaited in respect of respondent number 4.
Respondent number 4. You go for respondent number
1 and 3, Lordship.
1 and
3.
1 and 3. Third, Miss, your name please.
A.S. with the
Learned counsel for the petitioner and Miss
innocent.
for the respondent number
1 and 3.
1 and 2.
1 and 3, Lordship.
1 and 3, sorry. 1 and 3. Office note dated 18/7/2026 indicates that service report in respect of respondent number 4 is still awaited. Still awaited. So you want to take fresh step? The learned counsel for the petitioner submits that she will take fresh step upon the respondent number 4. Respondent number 4. Accordingly, it is provided that step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Madam,
In same order. Same. Okay, same order in both the petition.
file number 27.
Maybe, I know the petitioner, my lord, in this case, a notice was issued and my lord, LCR was called for. But petitioner says we LCR not received.
I say. Okay. Heard Mr. Rosid, learned counsel for the petitioner. Mr. Sinha for the respondent number.
On to say,
All the respondents. Since the TCR has been received, recess shall list the matter for hearing on
Short date will be given because fixed for today for final hearing.
Lord, there is the interim period, that will continue.
interim order pass earlier shall continue, list the matter. Public.
7.
Public.
28. And for respondent number 1 and 2, my lord, I have already filed a number and objection for 1 and 2. My lord, no sufficient cause is shown in the application to condone the delay, my lord.
The petitioner is absent today.
Yes, my lord, no sufficient cause is shown in the application to condone the delay, my lord.
Okay. Okay, after some time,
My
let
lord,
the council come.
yes. Items for admission. Item numbers 2 and 3, partner with.
Lordship, in item number 2 and 3, both I have filed IA for deletion of University Grants Commission as party respondent. IA number 1698 of 2026. But the petitioner institute which is there, it is an institute for technical education. But technical education institutes are not governed by the rules and regulations of UGC. So UGC need not be made a party respondent in these cases. In both the cases, I have filed separate IAs. I have categorically pleaded at para number 3, 2 and 3. That is an only subject as a college to be proposed to be started by the respondent number 1. The Technical Education Institute, which will run under the respondent number 4. And as such, the applicant has no role to play in it. Respondent number 4 is AICTE. So the rules and regulations of AICTE will govern the petitioner institutes. The rules and regulations of UGC will not be governed.
Mr. Mazumdar, you have received a copy of the IA?
Lordship, I received the copy, Lordship. As Lordship, last occasion, my learned friend, Mr. Budra Gogoi, Lordship, instance, they were implemented. I have not implemented, Lordship. They have no role to play, Lordship.
Oh.
The UGC,
It was filed in the month of
which they
May.
have categorically stated in their IA, Lordship. Both the two IA, Lordship.
Then why you have implemented them as party?
No, Lordship, not my instance, Lordship. I have not implemented, Lordship. This honorable court, as per instance of the standing council of the asked to Lordship.
In the petitioner, my lord, this is his petition. The IA was filed by the petitioner for improvement, my lord, both AICT and my lord.
No. Submitted by this honorable court, so the Lordship, the both the. As my learned friend, Lordship, let me submit, my lord.
To show that, my lord, UGC has given, my lord, specific instruction that, my lord,
No,
the university will have the right to frame the rules, my lord,
no,
for granting of affiliation.
this is the,
That was the my argument,
My-
my lord. I relied upon that. That's why honorable court said, my lord, that it can increase the UGC.
but now they are clarifying
My
the
lord,
position.
In addition to UGC, my lord, in both the case, AICT as well as the School of Architecture will have to be implemented because they are the main.
My lord,
regulatory
every day, my lord, my respect to,
One
let
by
me
one,
submit.
Mr.
Sorry.
Let him come. Yes.
AICT is a party developed in one case.
Both the cases.
Both the case.
In the other case, it is a School of Architecture. madam. Who is
Cannot
the
be.
Authority will give the.
Lordship,
clarification.
I have no grievance against the, yeah, Lordship.
For-
I have no grievance against the architect, Lord.
May be decided.
My learned friend is trying to delete the matter, Lordship, last occasion also.
No,
This
no,
honorable
this
court,
sort of submission will not do, my lord. If
No,
there is any
that's-
objection, my
that-
lord, ought not have filed it.
Mr. Mazumdar, please sit down.
Lordship, please.
This is his application, my lord. He also, my lord, said
no.
it before the honorable court. What is this, my lord?
No, never, I never approached, my lord, kindly peruse the order of the honorable court, Lordship, please to, as per his instance, they are implemented.
But I will
But-
rely on the UGC, my lord, the regulation, my lord.
How it
In
can
both
be?
the cases, my lord.
Once the UGC is denying their stand, Lordship, any involvement in the case, Lordship, then how he can rely, Lordship?
No,
This is
why not,
after
my
this honorable court.
I will,
And
my lord.
since the UGC is before this honorable court, Lordship, they have
UGC, my lord,
categorical.
There is no pleadings in the petition against the
No.
UGC. That's why they are saying that they have
No,
no role
no,
to
no.
play. Moment I place the regulation to show that, my lord,
No.
it is the UGC who has given us that liberty to frame the rules and regulations. And for granting of affiliation by the university, it is the UGC who is the main authority.
No.
In technical,
AICT, my lord, is the technical authority, my lord. They
No.
will only look into the
Cannot be.
curriculum and all, my lord, of the particular course,
No.
like, my lord, for engineering, diploma in engineering, or bachelor's degree in engineering, or say management, my lord, MBA and all. But, my lord, so far as the university is concerned, my lord, the university is also, my lord, required to give an affiliation for running that institution in the, my lord, state of Assam. That's why they have applied, they approached the, my lord, asked to, that is the science and technology. Then why is, my lord, that is required? otherwise?
I have not.
In fact, my lord, in the AICT regulation, we have given them the affiliation. They are just, my lord, a clear provision that, my lord, they will have to have the affiliation of the university also. Because the degree will be provided by the university. Examination will be conducted by the university, my lord, under whom, my lord, the petitioner is affiliated. It is not the AICT. And, my lord, so far as the second case is concerned, it relates to, my lord, for opening of a college for granting the degree of Bachelor of Architecture. And for architecture, my lord, course, it is the, my lord, National School of Architecture, which is the main apex body, not the AICT. He himself will rely upon the compilation, my lord.
No. I never, Lordship.
Now, so far the petition number 2176 of 2025 is concerned.
2176 is also again a technical education lordship. UGC rules and regulations do not apply to both the institutes because technical education is not within the realm of UGC, it is within the realm of AICTE. And as far as my learned senior submission with regard to the affiliation part, that they will be following the UGC regulations, that is their own prerogative, what procedure they follow. UGC is not binding them to follow the UGC procedure. That is their prerogative.
No,
It
if
is
they
not-
follow, if they follow the UGC regulation, then
That is their adoption. They are doing it on their own as an
no,
autonomous
in
body.
that case, whether UGC will not be a party,
UGC.
whether UGC will not be a necessary party here.
No lordship. They are
Yes,
adopting
Mr.
it for
Gogoi.
their convenience because they might not be having their own set of rules and
We have a set of
regulations.
rules, madam. We have a set of rules.
Let the entire matter may be hard. on
That's
that.
why my lordship will hear the
No.
entire matter.
But
So far as my lord adjourned it, AICT nobody is representing my lord.
no, AICT lordship,
Whether
it is up to them lordship. They have approved my institution lordship. With all respect lordship, why my learned friend is harping on that lordship? I shall try to satisfy your lordship because my only question is that whether NOC of the state government is necessary or not. True judgment of the Honorable Apex Court lordship clearly state that the NOC of the state is not required lordship. My respectful submission, it is a constitutional mandate lordship. State cannot make the law. It is a central act. I am guided by the central act lordship, AICT. So what is the use lordship? They have approved my
Okay, Mr. Bhuya, you say whether service upon respondent number 3.
Already
It
lordship,
completed.
both of them services will complete. I have already taken
No,
steps.
no,
Everything
in
is
petition number 2176 of 25. 3 is All India Council for Technical Education.
4 is UGC.
Whether service upon
lordship,
respondent number
lordship.
3
They have
complete.
accepted the notice lordship. Everything is. I have served the copies lordship.
When?
And office report is on that respect lordship is also there. I shall. Yes, I have a copy of that lordship. UGC and AICT, I have served the copies lordship. They have received. Since UGC appeared also, because the AICT, they have already granted approval lordship, with all respect lordship. If only for appellation matter lordship, these are same are pending lordship. I have served the copies of them to them lordship.
No, whether you have taken a step formally.
Lordship. The
Whether
standing
you have formally taken a step upon respondent number 3.
lordship. Both the respondents newly added respondent, I served the copies lordship, which is and UGC is before your lordship, and they have clearly stated lordship in their affidavit. I have in the morning I have gone through the affidavit. He has mentioned that affidavit page 7. I am the
Respondent number
undersigned
3 has filed affidavit.
who lordship.
Respondent number 3.
AICT,
Yes.
not yet.
So
AICT
when
not
the
filed.
notice was served,
Notice was served lordship. I have a copy of receipt lordship. I have produced the same. AICT and UGC, both of them received, and UGC responded lordship. UGC responded on that.
no, so far UGC is concerned, there is no problem. She has been representing the
Lordship.
UGC.
So
But in
UGC
respect of respondent number 3,
lordship.
AICT,
AICT lordship, I served the copies lordship. They received it. Standing council received the copies lordship.
who is the standing council?
Name is their lordship, Mr. Patak lordship, I think.
Correct.
Huh? All records are online lordship. Online report is also their lordship. They have received the copy lordship.
এই যে এইখনত লিখিছে চন্দ্ৰপ্ৰভা হালু চন্দ্ৰপ্ৰভা চিনি পায়?
বাইর করছিলেন বাবা
Okay, court master will contact the council. We'll take it up at 2 o'clock.
Lordship.
Madam, right now we will not consider your IA. We'll consider it at the time of final argument. Let us see. We'll take it up at 2 o'clock.
But 2 o'clock.
May I please, Your Lordship?
So service completed here.
Service complete.
Okay. You are representing the respondent. How many respondents are here?
One sole respondent.
Sole respondent. So what is the matter here?
Lordship, here, suit for specific performance of contract was filed against me, Lordship. And that was decreed expertise. Against that decree, Lordship, title execution was filed. And that title execution also already, Lordship, executed. In the meantime, I have filed a title appeal, Lordship, a time bar title appeal. And that title appeal, Lordship, along with the condemnation delay petition, I have filed the title appeal, but my condemnation delay petition was rejected. I am before your Lordship against that rejection of the Lordship.
That order was passed under
Section 5 Limitation Act. Lordship.
Limitation Act.
Limitation Act.
And your petition under order 9 Rule 13 was rejected.
Not rule that I have filed a regular first appeal. Not
Regular first appeal
regular
under
first
96.
96. That was my condemnation delay petition was rejected, but Lordship,
Therefore, that appeal was also rejected.
no, Lordship. Had the appeal been rejected, I would have filed a regular second appeal, Lordship. I would not have come under Article 227. Because that appeal, a consequential order for rejection of that appeal was not made. Only my condemnation delay petition was rejected, but no consequential order for dismissal of appeal was passed by the learned court below. As the no consequential order in the appeal has been passed, so there is no decree. The second appeal lies against the decree, Lordship.
No, what happened to that appeal then?
Appeal is in limbo, no order is passed. Lying in
No
limbo.
order is passed.
No order is passed. The appeal is lying in limbo. It is, technically, appeal is alive. As because no order has been passed in that appeal, which is required under Section 3 of Limitation Act, and also Order 41, Rule 11, Sub Rule 1, it is required to be dismissed. And Order 41.
Why don't you file an application there before the trial court then? Oh, dismissing the same?
Lordship,
Or the auto pass necessary order? Why don't you file an application before the trial court then?
that petition was
For passing an order in respect of the appeal?
that petition was not filed. So another thing is that, Lordship, another thing is that the title suit, the suit for specific performance was filed against only son. Lordship, the background of the case is that my father during his lifetime, he entered into an agreement, alleged agreement, which was not known to us, an agreement with the plaintiff for sale of the land. And after his death, Lordship, after his death, I and my mother, both of our name has been mutated in the records of rights as a legal heir, class 1 legal heir of Hemendra Kolita. My father's name was Hemendra Kolita. And after his death, our name was recorded. But the instant suit was filed against me only. My mother is also a necessary party, but she was not made party in that suit. And that was brought before the learned appellate court by filing the appeal. But learned appellate court failed to exercise jurisdiction, and that is why the invalid and ineffective decree was executed. As because necessary party, my mother was a necessary party, she was not made a party. So the decree itself is ineffective and invalid decree. And that was brought on record before the Learned Appellate Court and prayed for the stay of the execution. But Learned Appellate Court failed to exercise jurisdiction.
So,
That is the Lordship I am before.
where is the impugned order?
Here, the 1,322 days, my lord.
Impugned order, Lordship, started page 58.
They have taken, they have no knowledge about the cases, my lord. But they have.
At page
the
58.
notice and purposely they have not clear before the title sheet, I will let it the execution case. My lord.
Is there any document to show that they have received the notice?
My lord, page number 44, my lord.
44.
There is, I am not denying, Lordship. Notice, sir, but my, the dependent was, she was suffering from kidney disease. He could not participate in the proceeding, and ultimately the suit was declared expired, Lordship. I am not denying that notice was not served. I am not denying that.
Then,
It is on record, Lordship.
then why you could not
Expiry
file?
date-
Reflected in the order also, my lord.
No, why you could not file the appeal in time then? Where is your application filed before the trial court? Oh, sorry, appellate court? For condonation of delay?
Yes. Page 51, Lordship.
Page
51, Lordship.
51. Where you have explained the delay here?
Page 52, paragraph 3, Lordship. The petitioner appellant received one summons dated so and so of title execution case number so and so, and the petitioner appear in the case with his lawyer on so and so before Munship number 2 Nagaon. The petitioner is a layman and he has no any knowledge about this case. The engaged lawyer informed the petitioner about title suit number so and so and the ex parte order and ex parte judgment and decrees passed by Munship number 2 Nagaon so and so by learned Munship number 2 Nagaon in title suit number. Then the petitioner immediately apply on so and so for certified copy of ex parte order, ex parte judgment, and decree passed by learned Munship number 2 Nagaon in title suit number so and so, and certified copy of this copy receipt from copying assistance Nagaon on so and so. And after obtaining court fee, the petitioner appellant this appeal filed before the Honorable Court. As such, if the appeal is not considered on merit, there will be gross injustice to the petitioner and the petitioner appellant will be suffer irreparable loss and injury.
So where is the explanation for delay of
322 days.
1,382
days.
82 days?
22.
22. 22 days. Yes, is this explanation is sufficient here to condone the delay of 1,322 days?
This much explanation, Lordship.
Then
Petition in this petition, Lordship. Only this.
what wrong with the impugned order?
Lordship, wrong with
How it is illegal or arbitrary?
it is illegal arbitrary, Lordship. I am showing this, Lordship.
In fact, there is no explanation at all.
This I admit, Lordship.
Can this petitioner is a layman and he has no knowledge about the case? Is the ground?
This I admit, Lordship.
Then
Here, Lordship, my humble submission before your Lordship, my mother was a necessary party. And
no,
she
no.
was-
In this revision petition against the order of dismissal of your Section 5 application,
Lordship,
we cannot consider other aspects.
Lordship.
Here only we will consider the explanation put forwarded by you.
That is correct, Lordship.
That what is the explanation? If there is no explanation, then how the impugn order is illegal or arbitrary?
In the petition, Lordship, is explanation, elaborate explanation is not there. Lordship. I am relying on the judgment, Lordship, Honorable Apex Court judgment.
Who is
Because-
judgment?
Lordship, page 4, Lordship, paragraph 14, Lordship. And 11.
Page number?
Page number 4, Lordship, paragraph 14.
Yes.
There can be no quarrel on the settled principle of law that delay cannot be condoned without sufficient cause. But a major aspect which has to be kept in mind is that if in a particular case the merits have to be examined, it should not be scuttled merely on the basis of limitation. So here in
That's all
this
right,
case-
but how this decision will help him?
Where in my case, Lordship,
Since you have failed to file the appeal within the stipulated period, a right has already been created in favor of the other side.
Lordship, my another submission is that the spirit of limitation act is to end the litigation, Lordship, but not to validate an invalid order.
Maybe.
Lordship.
At the same time, injustice should not be caused to the other side also.
I may be.
So without any explanation, if we condone the delay, it will cause serious prejudice to the other side. 1,322 days.
Lordship, page 5, Lordship, paragraph 16. 16, internal paragraph 10, Lordship. We do not think the contention should prevail with us in the first place. It must be remembered that the rule which says that the court may not inquire into belated and still claim is not a rule of law, but a rule of practice based on sound and proper exercise of discretion. And there is no inviolable rule that whenever there is delay, the court must necessarily refuse to entertain the petition. Each case must be depend on its own face. There is no lower limit and there is no upper limit. It will all depend on what the breach of fundamental rights and the remedy claimed are and how the delay arose.
Mr. Islam, there are subsequent decisions where this proposition of law is almost overruled. Yes, what is your submission?
Not to allow the petition,
Not to allow the petition. Why?
because already 1,352 and the petition, the respondent is in possession of the land since 2010, They have already developed a lot,
Okay, we will pass the order and we will upload it in the website.
Obliged.
Anybody of judgment pertaining to
My lord, may I please, my lord? My lord, before my lord pronounces the judgment, my lord, I want to brought to your lordship's notice, my lord. I have filed one, my lord, IA, which is my lord, IA 138 of 2026, my lord. My lord,
Mr. Soikia,
my lord,
after reserving the judgment,
yes, my lord.
where is the question of filing IA?
My lord, because, my lord, some, my lord, material documents were not, my lord, placed before your lordship, my lord, for my lord, perusal, my lord.
No,
Yes,
whether the High Court rules permit it?
my lord, Supreme Court has also recently said that, my lord, before, my lord, signing of the
In which
judgment,
case
my lord.
Supreme Court has stated?
Case ka number. Just I will read out the, my lord, judgment, name of the judgment, my lord. They are said that before, my lord, signing of, my lord, judgment, my lord, if any, my lord can rehear the matter, my lord. That is, my lord, my lord, Vidya Das, Babuji versus Registrar General High Court of Karnataka, my lord,
Yes.
by the Supreme Court, my lord. Here
What
it
is
is held
what
that
is the ratio laid down therein?
my lord, before the, my lord, signing of the judgment, my lord, if, my lord, there material, my documents, my lord, for
It
execution.
says oral pronouncement not final. Judges can make changes and rehear matter
Mr.
until
Tara,
judgment is signed.
Mr.
Yes.
Tara, let Mr. Soikia complete.
No, that's what the judgment which he is referring to.
Okay.
That's what relating
Okay.
to an oral observation.
Oral
Okay.
judgment means, my lord, when the judgment is being not signed, my lord. And this is not an oral judgment, my lord. My lord has yet to pronounce the judgment, my lord. And my lord, that's why, my lord, here, my lord, neither the petitioner, my lord, applicants, my lord, neither the, my lord, writ petitioners, my lord, nor the, my lord, state government has brought the, my lord, correct material before this honorable court, my lord. In fact, my lord, there are two land acquisition
No,
notification, my
Mr.
lord, which,
Soikia, you see,
yes, my lord.
we have disposed of the petition on the
My lord.
on the submission made by the learned counsel for the
Yes, my lord.
petitioners. We have not
Petitioner two.
adjudicated the issue on merit.
Yes, my lord.
Then
My lord, they have said, my lord, they have, my lord, amicably settled a portion of the land. My lord, lordship, that is, lordship will find at page, my lord, the disposal order is, my lord, at page 50, my lord. In my lord, I also have a next, my lord. May I read just for a moment, my lord?
not necessary.
My lord, here, my lord, there, my lord, they have said that, my lord, my lord, they have settled 17.62 hectares of the land, out of 66.68 hectares, my lord. In fact, my lord, there are two
No,
land acquisition.
that was their submission.
Yes, my lord.
They have already filed one application before the deputy commissioner.
Yes, my
That
lord.
application is pending before the deputy commissioner.
No, my lord, that was, my lord, disposed of, my lord.
Which one?
That, my lord, application along with others claim, my lord, that was disposed of by the deputy commissioner, my lord. And after, my lord, disposal, my lord, the deputy commissioner has remanded the, my lord, matter before the, my lord, authority under section 64, my lord, before district judge Teju, my lord, for, my lord, resolving the issues, my lord.
Okay,
That was also not.
you go and agitate your matter there.
Yes, my lord. And it was, my lord, fixed yesterday also, my lord, at District Court Tezu, my lord. So this fact is to be brought to your justice, my lord's knowledge, my lord. That
No,
the
not necessary, Mr. Soikia, you see.
My lord.
Here we will examine whether this petition is maintainable or not, this review
My
petition.
lord. My lord, my lord.
So,
Because, my lord, in the writ petition, we are not made parties, my lord. And
maybe,
review was filed, we
maybe.
are not made parties in the writ petitions, my lord.
Mm.
There are two writ petitions. So we have implemented,
So,
my lord, has
Mr.
allowed.
Soikia, you say whether the petitioners are able to satisfy the requirement of section 47 of the CPC?
My lord, the writ petition is, my lord.
No, this
Applicants,
review petition.
yes, my lord.
My lord, at the stage of pronouncing the judgment, and if my brother's client is agreed, let him assail the order before the Supreme Court, not at this stage, my lord. Appropriately, it is not correct. That is
Ultimately,
what
my lord,
I
we
will
are
be
seeking
submitting.
justice, my lord. That's what, my lord.
Justice you seek
No,
in the
no.
Supreme Court, not here.
No, my lord.
Let him seek justice in the Supreme Court, not
If
here.
that
my
be
lord.
the case, my lord, they have, my lord, concealed the material facts, my lord, before this honorable court, my lord.
You are
They have
barred
neither
from
the
raising
annex,
this issue,
my lord, they have neither annexed that two, my lord, land acquisition notifications, neither the proceedings of the land acquisition notification before this honorable court, my lord.
Mr. Soikia,
Concealing? Yes, my lord.
Mr. Soikia,
My
you
lord.
say on what ground the review petition can be filed?
But if, my lord, some materials were not placed before, my lord, for proper education, my lord, and those materials were left out, my lord, inadvertently or, my lord, intentionally, my lord, not placed before
But
lordship,
you
my
are
lord.
not a party in those two writ petitions.
My lord, we have filed, my lord, implement application, my lord, and my
When?
lord has allowed those implement applications, my lord.
When?
My lord, implement is also listed, my lord.
When it was allowed?
My lord, implement application 82 of 2026, my lord. In the
In
review
which
petition,
case
my
it
lord.
was allowed?
My lord, in the same review petition.
No, my lord, the first review petition which he filed, because there the conduct of the counsel and the conduct of the petitioner, they have alleged the name, taken the name of the counsel of the respondent. Misleading like that. Then I raised a serious objection to that. And thereafter that review petition was listing, my lord, closed. And then he was given a liberty to file a fresh. Then there we raised the issue of a maintainability of the writ petition, review petition itself. So that is the only ground. Now, what is the requirement under law to bring certain additional affidavit and then file? So therefore, like any order, my lord, may pass, and if both the agree parties will agitate before the Supreme Court, not at this juncture of signing the pronouncement, at the stage of pronouncement of the order. That's it, my lord. Nothing to be heard at this juncture, my lord.
Yes, Mr. Soikia, it is not section 47, it is order 47 CPC.
Oh yeah, that is the only thing. There's nothing beyond.
Okay, we are pronouncing the decision. This review petition is dismissed with a cost of rupees 25,000 for using derogatory language not only against the council but also the court. The amount shall be deposited before the Gauhati High Court Legal Services Committee, Itanagar Permanent Bench within a period of 4 weeks from today.
Grateful, my lord.
Petition dismissed.
Timing item 28 orders.
That I am for respondent number 1 and 2. I have filed case number.
Lordship, the dossier has been served upon the respondent.
The respondent number 4, 5, 6, and 7. That's the yesterday upon us. And as
So service completed in all
yes,
the,
no, Lordship, what is the effect? Respondent number 3 has expired. But 6 can be during the pendency of the letter.
okay. So Mr. Ahmed, you have to file interlocutory application.
Lordship,
So bring on record the legal representative.
has received the same, Your Lordship. Babul Sundar Bora has received the same.
You furnish a copy to him. Let him file an application. Heard Mr. Ahmed, learned counsel for the petitioner. No, learned counsel for the applicant. Mr. Your name?
My lord. Respondent number 1 and 2.
Respondent number 1 and
2.
1 and 2. Mr.
P. Singh,
Learned counsel for the respondent number
4, 5, 6, and 7.
4, 5, 6, and 7. Who died? Respondent number
3.
Respondent number 3.
The mother of the respondent number 4, 5, 6.
The learned counsel for the respondent number so and so apprise this court that respondent number 3, who happens to be the mother of the respondent number 4, suffered demise on which date? 6/10/2023. In that way of the matter, the learned counsel for the applicant shall take necessary step to bring on record the legal representative of the respondent number 3.
Short date may be fixed, Your Lordship.
List the matter on COVID fixed next week.
31st of July.
So as to enable the learned counsel for the applicant to file an interlocutory application to that.
Okay.
Family items 2 and 3 for admission for attendance.
Okay, madam. Bidding for AICT on behalf of KP in the standing of the Milo. Lordship, are you present?
When he will be able to remain present?
2-3 weeks, Milo.
2-3 weeks.
Now we'll obtain the instructions, Milo. In the meantime, we'll let them also serve a copy to us, Milo.
Already served, Lordship.
Milo,
Then
they
again,
delivered it to the Delhi, Milo. So we can
no.
quickly.
Yes, sir. आप लोगों को रिसीव करो सर एटुको दूसरी यार एटुको हेलो
Milo, we are not this person, Milo. Some.
all right, I will start the copy tomorrow, Lordship.
That is not for
I
AICT.
don't know why.
You don't know?
Heard Mr. Mazumdar, learned counsel for
I'll
the
tomorrow serve, Lordship.
petitioner. And Mr. Your name, please?
B does, Milo, on behalf of KP.
B does a learned counsel appearing on behalf of Mr. KP Pathak, learned counsel for the respondent number 3. Ms. Agoral for the respondent number 4. Mr. Gogoi for respondent number
1 and 2.
1 and 2.
1 and 2. 1 and 2. 1 and 2. Mr. Das submits that Mr. KP Pathak, learned standing counsel for the respondent number 3. He is not present today.
Milo, because of medical emergency, Milo.
Due to medical emergency, he is not present in the court today. And he prays for listening the matter. After 1 week?
Milo.
After 1 week, learned
We record that the
counsel
during the final hearing.
for the respondent number 3 submits that he has not been furnished with a copy of the writ petition
By tomorrow, Lordship, again.
by tomorrow.
Tomorrow, Lordship, I'll make it.
Learned counsel for the petitioner undertakes to furnish a copy of the same by tomorrow. By
Milo, can
tomorrow.
it be taken after 2 weeks, Milo? We'll.
Lordship, there is a little bit urgency there.
No,
My learned friend.
we can fix the matter, but he has some
Lordship,
urgency. Urgency.
Lordship, it may be keep as part. I already had so many days, Lordship.
Okay, also heard Ms. Agarwal, Learned Counsel, in the interlocutory application for deleting the name of respondent number 4 from the array of this petition. Let the petition and interlocutory application be considered at the time of final hearing of this writ petition.
Admission. It may be date fixed, lordship may be.
Date.
Lordship.
COVID.
As part had lordship.
This is at least the matter is parted on.
30 July.
Lordship, 30 July, I already have 4 hearing matters, Lordship, it will be very
4th
difficult.
July or 4th August.
August, madam.
4th August.
Can it be on 5th, Lordship?
On?
5th. As it is, the affidavit is yet to be filed by AICT.
Okay, on 5th of August.
5th of August, lordship pleases.
Matter number 5.
May I please? The transfer petition, lordship. Transfer petition filed by the wife.
From which place to which place?
From Learned District Judge Sibsagar to Learned District Judge Tinsukia, lordship.
Oh, who is the petitioner?
The wife is the petitioner, lordship.
Wife is the petitioner. She is staying at Tinsukia.
Staying at Tinsukia, has been staying in Tinsukia since last 2015, lordship.
Okay.
My lord, I am the respondent, my lord, husband. My lord, the petitioner, my lord, earlier didn't find the, my lord, the transfer petition. Which is, my lord, the dismissed for default, my lord, that is
Pardon?
court, my lord.
Pardon?
Accordingly, my lord, the in the big court, my lord, the matter is going on, my lord, and court have on, my lord, I have certified copy of the appearance.
No, no, that petition was
Earlier,
Dismissed for default.
dismissed for
Dismissed.
default,
Okay.
but not on merit, lordship. Therefore, there is no bar.
Even, my lord, the counsel of the, my lord, the petitioner appeared before the, my lord, the district court. My lord. And it fixed for the, my lord, next date, my lord, on the, for, fixed for returns.
In 29th of
That is, my lord, on 2026, my lord. The council filed, my lord, Kalat number, my lord, on behalf of my lord, petitioner, my lord.
But that was not decided on merit.
My lord, that is true, my lord, but in my lord, in the second transfer petition, my lord, the petitioner, not my lord, the some, my lord, cases, my lord, pending before the honorable court, my lord, but not disclose this case, my lord, this petition, my lord. So my humble submission is not maintainable in the second petition.
Can on that ground we can dismiss this petition?
Also, I have already stated, lordship. Lordship, may kindly peruse.
Because, my lord, the petitioners, author, my lord. Now, my lord, with my lord, the other, my lord, with me, my lord. Now, she is, my lord, the 12, going to my lord, 12 exam, my lord. From my lord, class 5 onwards, my lord, with me. Only, my lord, to harass, my lord, the petitioner, my lord, the respondent, the husband, my lord. Five petitioner, my lord, the second test for petitioner.
Lordship, I have already stated, lordship. Lordship, may kindly peruse.
Lordship, no, my lord, the case from the government, my lord, not disclose all the material things, my lord, which is pending before the honorable court. One IA file that is the respondent, my lord, and the criminal petition also pending before the honorable court, my lord. But not disclose this
Lordship, earlier there was another council, lordship. And on that case, my learned friend has stated, lordship. On that case, I have not received any notice, lordship, as far as my client instruction, lordship. So some time may be granted, lordship, or regarding this issue. Because I have also taken the instruction from my client. She stated that she has not got any notice, lordship. And there is a maintenance case is pending before the learned JMFC Tinsukia, lordship. On that case, a huge year amount of maintenance is pending, lordship. More than 370 lakhs rupees, lordship. That has not been paid by them.
But this is, my lord, the both, my lord, children, my lord, including. Now, my lord, the daughter, my lord, with me, my lord.
That is, I admitted, lordship. I have already stated in my petition.
Class 5, my lord, kindly see, my lord. With me, my lord, now he is going to, my lord, appear back class 12 exam.
But my son is residing with me, lordship. He is studying at class 10, lordship.
He is also ready, my lord, to son, my lord. But the,
No, now we are concerned with only the transfer petition.
That's why, yes, lordship, that is right. And second transfer petition is maintainable, lordship, because earlier that has been decided on merit, lordship. And Supreme Court has also.
Then you come prepared. We will examine the maintainability of the second
Lordship,
petition. We'll fix a short date.
Short date.
But Metropolitan Learned Counsel for the petitioner, Mr. Dehingia for respondent. List the matter on cover fixes of that.
Also, before 29, the matter is fixed on 29/7 in the lower court.
27.
27. Okay.
27. For hearing on the point of maintainability of this petition.
Okay. Obligations.
Items for hearing. Item number 15.
May I please
Hmm.
we have filed we have filed this notice to the petitioner as we don't get any instruction from the petitioner to file for the objection. So, Your Honor, if
in any way, Lordship, in this case, what happened in the plaint itself, there's a government is a party, Lordship. Today, when I have seen that government is not there, then I have checked my appeal memo. In appeal memo, government was not made party. So in also, I am going to file an impleadment application to implead government, Lordship. As because the plaint there is a party, respondent number 2 and 3, State of Assam, page 9, Your Lordship, kindly see. In the meantime, they can communicate with their clients, Lordship.
Your Lordship, we don't know whether the petitioner is still alive or dead or that's, we don't find any response from the petitioner's end.
That Lordship, I have checked, they are Lordship relatives. So the plaintiff, both the plaintiffs are alive, still alive, Lordship. Page 9, Your Lordship will find. Plaintiff number 1 is Akoi Mia, plaintiff number 2 is Hokoi Mia, Lordship. And they are still alive. Today morning, I have.
You have issued notice to them.
Yes, Lordship. They will get chance, Lordship. In the meantime, I will file my impleadment application. As because defendant number 2 and 3, Lordship, they remain not represented.
Learned Senior Counsel assisted by Ms. So Learned Counsel for the appellant. And Ms.
A. Kharbani,
Learned Counsel
on behalf of D. Chaudhary.
appearing on behalf of Mr. T. Chaudhary, Learned Counsel for the respondent. The Learned Counsel submits that, Counsel for the respondent submits that they have not received any instruction from the respondent, and as such, they have issued notice to the respondent. And say press for listing the matter after 2 weeks.
Lordship, 2 weeks, Lordship.
After 2 weeks. They are allowed to list the matter after 2 weeks.
Oh, Lordship, after 1 week, I can file when the next week
that.
itself, Lordship.
In this appeal, the state of Assam, how they are required to be made a party?
Lordship, by it may be typographical mistake. Lordship may see the defendants became appellants in this regular second appeal, and then the plaintiffs were made parties, page 3, Lordship. Akoi Mia and Hokoi Mia, respondent plaintiffs. Thereafter, Lordship, the defendant number 2, 3 were not made party in this regular second appeal. And they are still present in the decree of the first appellate court, Lordship. So their presence is required, and one more defendant.
Who are respondent number 2? 3 is there, 2 is not there. No, 2 is there.
2 is there, Lordship. Lordship will find page 9, the original plaint. The defendant number 1 became now appellant, Lordship. Page 9, plain type copy of plaint, Lordship. Defendant number 1 became appellant in the regular second appeal.
So
and
defendant number 2 and 3.
2 and
they
3
are required to be pleaded.
Yes, Lordship. And one more, Lordship, that is 5, page number 10, Moina Bibi. She was also not made party in the regular second appeal. Maybe due to typographical mistake, Lordship.
Whether they were before the first appellate court?
Yes, Lordship. In the decree itself, their name is there.
Okay.
Page 73, Lordship.
Ms. Chaudhary, Learned Counsel for the appellant, referring to the plaint, which is annexed with the memo of appeal, as annexer 1 at page number 9, pointed it out that uh, the state of Assam was implemented as defendant number 2, and the sub-register Karimganj was implemented as defendant number 3, and
Defendant number 5, Moina Bibi.
defendant number 5, Moina Bibi.
She is a resident of Bangladesh, Lordship.
Moina Bibi have not been arraigned as a party in the RSA number 294 of 2014. And in order to adjudicate the issues, and in order to adjudicate the substantial question of law so formulated in this appeal, the aforementioned defendants are required to be arraigned as a party in the memo, no, in this RSA also. And say price for granting her some time to file implement application. Fair enough, please the matter after 2 weeks.
Obliged, Lordship.
Item 17, sorry, item 16.
May it please your lordship, and this appeal is filed against the concurrent finding, my lord. And one of the substantial question of law is there in Farber City, my lord. Therefore, evidence part is required, my lord, but file is hand over to me yesterday, my lord. Then from after going through the file, there is no evidence on in the file. So file evidence is required. I may be allowed to take certified copy of the evidence, my lord.
Yes, Mr. Sayola. After then we will fix the matter after.
After 2 weeks, my lord, in the meantime, I will.
You're also see, madam, this matter was listed more than 15 times for taking, madam. They have taken time on this sort of grounds. 2016 matter, madam. That madam, I don't know, madam. And moreover, madam, the agency not before, madam, the background is there.
First substantial question of law is there regarding whether the learned courts below committed perversity in declaring the plaintiff's exclusive right, title, and possession over the suitland, in as much as the evidence and record shows that the plaintiff and the defendant numbers 1 and 6 did not divide their ancestral.
Let us fix a date. Heard Miss Roy, learned counsel for the appellant. Mr. G. N. Sayola, learned senior counsel, assisted by Miss Todi for the respondent. Miss Roy submits that she has been engaged in this matter yesterday only, and
No,
in order to
I am there, I am there, my lord, but the hearing is to be done by, is required to be done by J. Barbuya, but
no,
he has handed over the
you
file.
have submitted the, you have been engaged yesterday.
No, I have not, I'm said that file was handed over to me yesterday. my lord.
Yesterday,
Yesterday.
that the file was handed over to her yesterday only, and she has to go through the evidence to address this issue in respect of the substantial question of law number 1, and therefore she prays for listing the matter after 1 week.
1 week, there is little difficulty to obtain the certificate copy, my lord. 2 weeks, my lord.
After 2 weeks. Okay, fix a date. Fix a date. 6 of August. 6 of August. Since this matter is of the year 2016, no further adjournment will be granted to any of the parties.
Item 19.
This is also 2019 matter. Heard, Mr. Yudas, learned counsel for the appellant. Mr.
Yes, sir.
Yes, sir. Borbuya, learned counsel for the respondent. Mr. Borbuya, press for listing the matter after.
My lord, matter will be kindly fixed on 4th August, my lord, Tuesday, my lord, this is.
4th of August.
After one.
After 1 week.
Yes, in the middle of the.
Before 15th August, before 15th August,
15th August, 13th August.
13th of August. 13th of August.
Kindly on the 11th August, my lord. On 13th, my lord, I have some problem. On 11th, my lord.
11. Okay, 11.
Okay. Bill number 20 by receipt of
Lordship, in item 15 in IA, Lordship, there is a status quo order. I forgot to mention that. IA 2391 oblique
Interim order
2020.
passed in the IA number so and so shall continue.
2391 2023. Order dated 23/8/2023.
Okay.
Authorized, Lordship.
item 20 by receipt of
Please, your lords.
The lordship in this case, the LCR has not been received.
Lordship, my senior is on late. Please pass them at a time being.
No, the LCR has been called, my lord, so.
Okay, I will fix a date for record, trial court record. Art Miss, your name please?
A. Sharma, on behalf of
Learned
B.
counsel
Chakraborty.
appearing on behalf of
B. Chakraborty.
B. Chakraborty, learned counsel for the appellant. And Mr. Your name please?
Your lords, yes, your lords. Your lords, am I audible?
Yes.
Yes, your lords, I'm Nirmal Goenka, your lords. I'm appearing for the liquidator. Your lords, there's a peculiar fact in this matter, this regarding this IA 2202. Your lords, as per the last order, though this IA was directed to be heard along with the RFA, I'm pressing for this IA, your lords, again. Your lords, there's a very small issue which is involved in this because the company against which this.
What is the pair in the IA?
Yes, your lords. Yes, your lords. Your lords, IA 2202, your lords, it's actually what has happened is, your lords, this company, Gauhati Construction, is under liquidation, your lords. So, and your lords, this appeal was filed against an order by the trial court. So, your lords, I am only requesting that I be I be permitted to assign all my rights to the prospective purchaser so that I can close the liquidation. The liquidation has been going on for quite some time, your lords, in this matter because of this litigation, because of a status quo order passed in this matter, your lords. So I was only requesting that I kindly have the prayer, your lords. It's at page number 15 of my IA. It's a very small application, your lords, so that it will assess the liquidator in closing the liquidation.
Page number?
Your lords, page number 15 of my IA.
Yes.
Your lords kindly have. Permitting the applicant liquidator to assign the assets of Gauhati Construction as NRRA as is where basis with all the litigation and encumbrances, your lords. So, lords, I will only step out and another person will step in and continue with this litigation. So nothing will change as far as these proceedings are concerned. So I was only requesting that may be permitted because of a status quo order passed by this court. I am not able to close that liquidation.
Lordship, it was heard several times. That's why whole matter has to be heard. That's why he's come up for hearing. For final consideration of the RFA, Lordship. The I was made subject to the outcome of the RFA, my lord. What had happened in this case, my lord? The liquidator, that is the company which is under liquidation, the company holds some development rights over a land, and the land belongs to me, my lord, as a owner. I am the respondent number 2 and opposite party number 3 in the I, my lord. And there was a case between the owner and the railways, my lord. And the learned trial court has decided the said case in my favor, and a RFA has been preferred by the railways, my lord. So the point remains that the company which is under liquidation is not the owner of that land, my lord, first place. Secondly, they are holding only development rights over that land. And my lord, the company itself has gone into the liquidation, my lord. Importantly, my lord, this application it's not maintainable at per se, my lord, because regulation 37 7, my lord, may I read that regulation, my lord, that is very specific.
Mm.
So the provisions of this regulation shall not apply, my lord.
Mr. Chakravarti,
Lordship, it's
uh, we cannot dispose of this IA without hearing,
whole
finally
matter has
hearing
to be
this.
heard, Lordship.
That is your contention.
Lordship,
So let us fix a short date then.
Lordship.
Please, your lords.
We will finally hear and dispose of both the matter.
Please.
Lordship.
Mr. R.N. Goenka, for the, are you party in the RFA?
Yes, your lords. Your lords, I am representing the Guwahati construction because it's under
Respondent
liquidation.
number, your respondent number,
Your lords, it should be the respond number 1, your lords, in the RFA.
respondent number 1.
Yes, your lords.
And you are for respondent number?
For respondent number 2 in the RFA, my lord.
Respondent number 2 in RFA. Office note dated 18/7/2026 indicates that. No, not that office, no. 16/7/2026 indicates that TCR has not yet been received. Accordingly, it is provided that RSSL urgently requisition the record of the trial court and list the matter after 2 weeks. After 2 weeks.
Lordship.
Any objection, Mr. Goenka?
Your lords, a date
After
may
2
be
weeks.
fixed. I'm just requesting for a date to be fixed, your lords.
Okay, cover it.
On 13th August.
13th of August.
Oblige, your lords. Highly obliged.
Item 21.
Well, you lost. My lord, last occasion, my lord, I have pointed out as regards to the amicable settlement. In that regard, my lord, communication was made, my lord, no effective result has been come out. Because, my lord, in that regard, my lord, my client has communicated with this present respondent, my lord, he has not responded as of now. So, my lord, matter may not, there is no possibility at this stage, unless and until that part they have, my lord, made discussion in that regard, my lord. So, in relation to that amicable settlement, what happened, my lord, in an execution proceeding where 3 persons have get together, and in that relation, my lord, communication was made as regards to amicable settlement. And as of now, present status is such that no settlement was taken place in within that.
So then we can finally hear and dispose of the matter.
My lord, that's.
Are you ready to argue the matter?
If it possible, my lord, next week it may be taken.
It should be taken, stay is going on, Lordship.
Yes, sir. So for that part is concerned.
No, I am ready to hear the matter. If he is not ready, then
Tuesday, my lord, if you lordship, please, my lord,
next Tuesday, not possible. In the second week of August.
Second. Hearing day, my lord, on any
Okay,
hearing.
heard Mr. M.K. Sharma, learned counsel for the petitioner, Mr. Putter for the respondent. On the pair being made by Mr. Sharma, learned counsel for the petitioner. This matter is then adjourned to be listed on 6th of August. Okay.
Oblige. Interim may be complete.
Interim order pass earlier shall continue.
Oblige.
Items 22 and 23.
Yes.
Lordship, there are two appeals
Mm.
arising out of common judgment.
Mm.
So, Lordship, I pray for some time in the next.
Why?
It will take some time for me, and I have already talked to him other side also.
It is only 2:45 now. How much time it will take?
Because I can't say Lordship because I don't know as the things progresses.
Yes, Dubey?
But on this, on my part, but my friend is to start. The very interesting issue is about that as regard one appeal, whether against the appeal, whether two appeals are to be filed, like for dismissal of the suit and allowance of the counterclaim.
Two appeal.
Yes.
Trial court decreed my suit, dismissed the counterclaim of the defendants. Appellate court, by common judgment, there was only one appeal was preferred against that by the defendant. In appellate court, it was totally reversed. Set aside my judgment and decree, and decreed the counterclaim. As against that, we preferred two appeal. One it was in then and there in the year 2018. Thereafter, with limitation petition in the year 2025, second appeal was preferred. As against the suit, as well as judgment passed on the suit, as against the counterclaim also. So presently there are two appeals because this court already framed the issue. Both the appellate court, this honorable court framed two issues on the point alone, whether two appeals should have been preferred or not. One. Second point as regards to the non-gender of necessary parties. What is necessary parties? So I need some more time because this point has to be also seen because there are various judgments on that. There should have been two appeal before the first appellate court, but it was not done. Therefore, first appellate court judgment will prevail or not in any way, because after all, an appeal against the suit or against the counterclaim.
No, that has not been indicated in the memo of appeal.
We had filed a common appeal against both, whether that could be done, that is the issue.
Can a common appeal be filed?
Yes, so far my contention. Way back in 1950, Apex Court has decided that issue. Very interesting issue.
Okay. Okay, when you will be able to argue the matters?
But in fact, I had a talk with the senior counsel, Mr. Deka, who is appearing on behalf of the appellant on 6th of August, if your lordship can.
6th of August, not possible.
I understand, but because otherwise also it will take time. Some emergency there on my part, my lord.
After 15 hours.
It can be given.
Heard Mr. Bhagavati, learned counsel for the appellant, and Mr. Dubey for the respondent.
May I indicate one thing, Lord? In the second appeal, my name has not been shown. Well, I appeared, that should be shown.
Mr. Dubey submits that his name has not been reflected in RSA number
59
of 2029.
117.
117. In 117 of 2019. Rest shall do the needful in this regard. Mr. Bhagavati submits that this matter may be adjourned to another date as he needs some more time to address this court in respect of the substantial question of law. So formulated
Number
by the
one.
court, right, order dated 4/8/2025. Here allowed, list the matter on 18th of August.
Lordship.
Items 29 and 30.
May I please, your lordship?
But in this case, your lordship has passed him order dated 2nd of June.
In 2026.
There was a direction for calling of the records, but all the records have not come. Out of the 4 records, only 2 have come from the lower court. There is an office
So
note
do you
also.
have the number?
But appeal number and title execution has come.
Title appeal, both title appeal.
Title execution has come.
Title execution one has not come.
Title appeal number 2 of 2014,
Yes, has been received.
35 of 1999 have been received.
Yes, Lordship.
But title suit number 271, title suit number 350, and title execution case number 1 have not been received.
Yes, Lordship.
From where it will come?
Lordship, title suit number 271 from Civil Judge, Civil Judge Senior Division 2, Kamrup Metro.
Okay.
Lordship, title suit number 350 from Junior Division 3, Kamrup Metro. And title execution 1 from Junior Division 3, Kamrup Metro.
Okay. Heard Mr. Mukit, learned counsel for the
Lordship, W.
appellant,
Hawk.
Mr. Dubey for the respondent. Office note dated 28th July 2026 indicates that though the record of title appeal number 2 of 2014 and 35 of 1999 have been received, yet the record of TS number 271 to stroke 2004, TS number 350 of 1995, and title execution case number 1 of 2002 have not yet been received. Accordingly, it is provided that registry shall issue urgent reminder to the learned courts below for transmitting the aforesaid records by special messenger. List the matter after 1 week or Kavil?
2 weeks.
After 2 weeks. So do we fix a date here?
But can your lordship indicate the court from which it has to be called? Otherwise, not there. We also tried. The records are not been available.
From the court of, in the earlier order, it was reflected.
Yes, Lordship.
Civil judge.
It was reflected.
Only case number. What?
No, in the order it is reflected.
It was there. But
Order dated
was there.
2/6/2026. Reflected, Lordship.
It is reflected.
My lord. Yes.
From the courts below, in view of the order dated 2/6/2026.
But can I pay for a fixed date?
Kavil.
Lordship. Sir.